afternoon, all. Welcome to the Appellate Division First Department. We have oral arguments for today, April 8th. We have 7.5 hours of argument time requested, so I'm going to ask that you please only ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we have read your briefs and we are fully familiar with those arguments. People v. Ruck. That matter is submitted. Labda v. Toro College. That matter is submitted. Matter of Monet. Submitted. Garrido v. 200 Lenox Avenue. 525. Cortland v. TPG.
For appellant Apex Partners, Your Honor, we request 5 and 2. TPG-related appellants, we request 5 and 2 as well.
52526. People v. Thomas Nicholas. 424. People v. Johnson. 525. Breeding v. High Hopes. 324. Clemente v. City of New York. 523. UBS Securities v. Dondero. Respondents? 416. So 41416. That case will be called first. People v. Isaiah Sullivan. All matters are submitted. Dodeja v. Total Concrete. That matter is submitted. People of the State of New York v. TikTok. How much time are you? Go ahead. Sorry. Go ahead. 838. Molasek v. ExxonMobil. 526. Garcia v. 267 Development. Did you want time in rebuttal? 523. Variano v. Variano. 525. People v. Cabrera. Is there a respondent? 5 and 1 and 3. Enriquez v. Nycha. That matter is submitted. As I stated, the first case for argument is UBS Securities v. Dondero. Yes, whenever you're ready, just state who you're representing and what issue you will be arguing.
Thank you. Deborah Deitch Perez from Stinson for James Dondero, and I will be addressing the alter ego argument
Proceed.
for James Dondero.
Okay.
The transaction for which UBS seeks to hold Mr. Dondero personally liable is the 2008 Knox transaction, and that failed because of the 2008 financial crisis.
Counsel, could you put your microphone closer? Thank you. What is the transaction?
The Knox transaction, which was a transaction that failed and was breached in December of 2008, that was the end of it.
The Knox transaction.
The Knox
Is
transaction.
that the only transaction, or any transactions which flow from that, or just that transaction?
That is the transaction for which UBS seeks a $1 billion judgment. There is only one set of judgments. It is for breach of contract. It is a breach of contract that happened in December of 2008, and that's the basis on which they seek the billion.
Well, they're seeking to enforce the judgment based on that transaction, correct?
They are. But the difference is the only, alter ego is not a separate claim. It is a basis to hold someone liable for the obligation of someone else. The obligation that's $1 billion that UBS is seeking to enforce against Mr. Dondero arises solely out of that 2008 Knox transaction. There is a separate fraudulent transfer claim for 2017 activity. That is not the basis for alter ego here. The claim they're seeking $1 billion for is only the Knox transaction.
Well, they're seeking to enforce the judgment based on that transaction. So why would we sort of divorce the judgment from the action?
Because what Morris says alter ego liability requires is that the alleged alter ego have dominated the alleged alter ego with respect to the transaction attacked. Here, the transaction attacked is the Knox transaction because that's the basis for the $1 billion judgments.
Why can't the plaintiffs say that they're attacking the transactions, so to speak, that allegedly led to the dissipation or waste of the assets of the entities that could have been used to satisfy the judgment?
Because that's a fraudulent transfer claim that needs to be made with respect to the recipients of the transaction. There's no allegation that Mr. Dondero received the proceeds, and that's not the basis for the alter ego claim. The alter ego claim is to hold Mr. Dondero liable for the original judgments, which that's the only $1 billion claim.
Do you have a strong case you can point us to that defines that term, transaction challenged? Because it seems to me you could read it could either be a term of art that challenged transaction is the underlying transaction that gives rise to the liability, or more colloquially, it could be any transaction that relates to the corporate liability that the plaintiff is seeking satisfaction on.
And yes, if you look at the Lowendahl case,
I'm sorry,
the Lowendahl case, that's a case where the transaction attacked is in the past, and the court said that these newcomers were not involved in that transaction, and so they could not be liable. And so if you look at all of the cases that the lower court relied on this prong of Morris, if you actually parse them, you will see that the alleged alter ego is alleged to have dominated with respect to the underlying wrong. So it's entirely different than this case, because otherwise what would happen is you would have a company doing something, incurring obligations, and then anyone later could come in and be held liable for that if they choose to pay one obligation.
Not at the drop of
over
a hat.
another.
What was the ATE policy for?
It was to pay obligations of the judgment debtors.
And it was after the
anybody-
lawsuit had been initiated, is that correct?
It was later, yes.
Did
And in
any money
fact,
actually go
UBS
toward paying the judgment?
Excuse me?
Did any money from the insurance
Yes.
policy actually go toward
Well,
paying?
money from, the assets that went to Sentinel, and Sentinel was the insurer, went to UBS. They have already recovered.
Sentinel is not like a separate entity outside of your client, right?
Yes, it is. It is.
But your client created and also ran and dominated Sentinel.
No, that's not correct.
Oh, so who?
What was the relationship between the two?
Mr. Dondero owns a company that owns part of Sentinel.
And who owns the other part of Sentinel?
Another entity that Mr. Ellington owns that owns part.
Are these
There are two
mainstream and
Yes, Mainstream and Montage.
Montage?
Yeah.
So they own Mainstream and Montage, which then create Sentinel, and so they're somehow.
There's a board that.
But they're the only two people on the board, right?
but there-
Dondero and Ellington.
Yes, but they only have a certain amount of voting power, and it's
How can they
their-
only have a certain amount of voting power when they're the only individuals on the board? They comprise the board.
they do comprise the board, but they do comprise the board.
You have time on rebuttal.
May it please the court, Robert Lack for appellant Scott Ellington. I'll address alter ego with respect to Mr. Ellington, also fraudulent conveyance. In 2008,
So Mr. Ellington was essentially an employee of the other gentleman, correct?
he was always a subordinate of Mr. Dondero.
A subordinate, you said?
He was a subordinate of Mr. Dondero. In 2008, he was a low-level in-house real estate lawyer. He had nothing to do with the Knox transaction.
Well, low level, would we call him low level? Because there's some characterization of him being sort of, you know, the person to achieve all of the goals of Dondero.
Well, later, years later, in 2011, well, after the Knox transaction was entered into and breached, Mr. Ellington was promoted to general counsel. He was general counsel at the time of the 2017 transfers, but he had nothing to do with the Knox transaction.
So he took no part whatsoever in anything to do with the Knox transactions in 2008?
Correct.
Mr. Dondero never directed him to do anything in 2008?
No, because he was in the real estate department. The Knox transaction was a complex securitization transaction involving collateralized loan obligations, not real estate. Mr. Ellington had nothing to do with the Knox transaction. And when the damages to that transaction were realized and set, which was December 5th, 2008, Mr. Ellington was just a real estate lawyer. He had nothing to do with it. So the idea that Mr. Ellington could be held liable for $1 billion, which is ultimately what the damages became when the judgment was entered, is not cognizable within New York law.
Mr. Ellington owns a share of Sentinel, the entity created as the insurance after the fact, after the event?
Mr. Ellington was an entity that Mr. Ellington owned was a 30% beneficial owner of Sentinel. Yes, that's right. And Sentinel was the one who received not $1 billion, but received $100 million. And there is a separate fraudulent transfer claim against Mr. Ellington with respect to those transfers. But fraudulent transfer is a claim against the transferee for the money the transferee himself received. And in this case, Mr. Ellington didn't receive $100 million. He received, according to the petition, in the low millions of dollars. So it was incoherent for him to be sued for $1 billion or $100 million. And he could be sued for fraudulent transfer for the low millions, but for the fact that that claim is time barred under the Texas statute of repose. And the reason it's time barred is because Texas has the predominant interest under interest analysis in having its law applied.
Why are we applying Texas law instead of New York law?
Because under interest analysis, fraudulent conveyance is a conduct regulating law or tort, and the conduct in question here, which is being challenged, was the 2017 transfers from the judgment debtors to Sentinel. There was no New York-based conduct to be regulated in 2017. The whole point of the fraudulent conveyance law is to regulate the activity of the transferors. And the transferors here were the judgment debtors who were operating through Mr. Ellington and other agents who were based in Texas. There was nothing relating to New York relating to the transfers. And so
The fraudulent transfers deal with trying to evade a New York judgment, though, isn't that correct?
Oh, well, that's the allegation.
That's the allegation.
That's the allegation here. But
Speaking of allegations, right, at this posture, right, we're taking the plaintiff's allegations as true, right?
yes.
What about the allegations would you say are not enough to sustain their claim?
Well, the allegation, well, first of all, there's a statute of limitations, a statute of repose, which would bar the claim even if the allegations were all believed to be true, taken to be true. So that's a separate thing. But our point is, if you were assuming that the whole 2017 transfers were intended to defraud, then the remedy is one of fraudulent transfer law. That remedy is against the actual recipient of the money. The recipient was Sentinel in the first instance. Sentinel gave back those assets. Those $100 million of assets were given back from Sentinel to UBS in a settlement. And so what Mr. Ellington is being sued for is being a subsequent transferee. And the money he got in the subsequent transferee was limited to a small amount of expense reimbursements for various trips and for money that was paid to him through this mainspring entity. But that total only is several $1 million. It's not $100 million, it's not $1 billion. So we think the claim against Mr. Ellington, if it's not dismissed based on statute of repose, should be limited to the low millions of dollars, which are the only amounts that he actually received.
You have time on rebuttal. Thank you.
Thank you very much, Your Honor.
Good afternoon, Your Honors. May it please the court. Roman Martinez for the UBS entities.
So can we deal first with Mr. Ellington? How is, if he were in the real estate department in 2008 and had nothing to do with the Knox transaction, how would he be held liable?
He was held liable because he became the chief legal officer of the entities and served as the second in command, helping mastermind the domination of the company and the siphoning off of the
That was in 2010, right?
He became CLO in 2010, and then he was, throughout the period that followed, which is the period during which the judgment debtors had an ongoing legal obligation to pay money as a result of the termination of the Knox transaction. Mr. Ellington was the one working hand in glove with Mr. Dondero to
But
use...
he was a subordinate to Mr. Dondero, right?
He was a subordinate to Mr. Dondero, just like the alter ego in the Berisha case that we cite was the second in command there. But that didn't prevent this court from saying that a second in command can be an equitable owner, can be held liable as an alter ego when you do things like what Mr. Ellington did. He had signatory authority. He controlled the litigation strategy. He was overseeing this web, this endless parade of shell
What
entities.
specific facts did you allege to establish that he was an equitable owner, such that he could be deemed the alter ego?
So I think if the place to look would be at pages 67 to 72 of the appendix. We allege that Ellington disregarded corporate formalities, intermingled funds, shifted money to undercapitalize the debtors, most egregiously with the 2017 phony sham insurance transaction.
All of this has as a predicate that the transaction that is attacked is subsequent to the 2008 Knox transaction.
I think the transaction that's being attacked is the ongoing failure to pay the legal obligation that arose from the breach and the termination of the Knox transaction, and also it was looking forward the effort to evade what the entities on the other side, the alter egos, knew was going to be the inevitable judgment against them in the litigation that was ongoing.
Is your friend correct, though, that Lowendahl suggests that the transaction attacked refers to the underlying transaction that causes the obligation?
No, only in a case, Lowendahl is a case where the obligation was consummated and it was complete at that initial moment. This is a case that's different from that, where the obligation to pay money arose in December of 2008, but that obligation was not satisfied. It was an ongoing obligation that was never satisfied. They had a duty to pay under the contract starting in 2008, and they didn't pay it.
Contract
This
was
case is
terminated
more
in 2009 by your client, right?
I'm sorry, Your Honor.
I'm sorry. The contract was terminated by your client in 2009.
In 2008, and the termination of that contract.
2008?
Yes, December 2008, I think it was the first week of December 2008. And what happened when, under the terms of the contract itself, once the termination happened, there was an obligation to pay money that arose. And this is at pages 1712 and 1746 of the record. 3 days later, the judgment debtors had to pay money to make whole UBS for the diminution in value. That obligation to pay started then, and it continued. It was never satisfied.
So you seem to be posing this under some type of continuing wrong doctrine. Are there any cases that support that?
Absolutely, Your Honor. I think the best cases for us are the Azte case and the Chung case that we discussed in our briefs. And let me just tell you what the language from Azte was. Azte is a case...
Chung, all right, just starting with Chung, that was Judge Edmead's case, right?
Right.
That was a rental case. So there was a rental obligation that continued.
But the failure to pay money, which the obligation to pay the money for the rent was never satisfied. And here's what the Chung court said. The transaction the plaintiff seeks to attack is the avoidance of obligations created by the lease as evidenced by the non-payment of rent and the eventual judgment resulting therefrom. Same thing here. It's the ongoing failure to pay the money that came due as soon as the Knox transaction was terminated.
But it's a little bit more than that. You're claiming not only the failure to pay the money, but also that they're using the money for other purposes.
That's exactly right. So for purposes of identifying the transaction attacked, for purposes of the first prong of the Morris analysis, it's the failure to pay this obligation, which they never satisfied. If someone owes you money, they don't just owe you money on day one. If they don't pay you, they continue to owe you money on day 2, 3, and 4. And
Is that a continuing wrong? Is that a continuing wrong or simply the effect of one wrong that took place at a particular time?
I think continuing wrong is a phrase that comes up in the statute of limitations context, so I would resist just sort of importing that concept here. But colloquially, I do think it is a continuing wrong in the sense that, again, if I borrow $5 from you and I'm supposed to pay you back the $5 on Monday at noon, and I don't pay you at Monday at noon, and we get to Tuesday, I still owe you the $5. I still have that continuing obligation. I'm still participating in a continuing wrong by not paying you.
You got to concede that New York State disfavors disregard of the corporate form. We all know that. So doesn't this create this enormous window in which an alter ego liability can be imposed?
It creates a window of time in which if you have a person who's committed the kind of outrageous conduct that was at issue here, who comes in and satisfies both very demanding prongs of Morris, they dominated the company. They dominated it with respect to the underlying liability. And then at prong 2, they committed a wrong that was designed to and completed and successfully deprived the victim of money, that there is going to be alter ego liability in those circumstances. That's
Under your theory,
satisfied here.
there really isn't a statute of limitations because it's tied to this judgment. And so I guess you would say that you're free to come in and you're free to seek to pierce the corporate veil for the 20 years that the judgment is valid for.
I think that's the theory of turnover, a turnover liability and the turnover proceeding. When you're proceeding under an alter ego theory, you can get the judgment first and come in later. I'll just say the reason that some of this stuff wasn't aired earlier is because all of this, the domination and the sham insurance policy, all this stuff was hidden from UBS.
See, the other thing, counsel, is you mentioned a domination. So in your complaint, I think you state that Mr. Dondero unilaterally made decisions, ultimate decision maker for the judgment debtors. But then, by the same token, you're saying that Mr. Ellington also exercised control. You also say Ellington, as Dondero's right-hand man, also exercised unfettered authority over the judgment debtors. So how do you have it both ways? On the one hand, Mr. Dondero is unilaterally making all of these decisions, is the ultimate decision maker, and then Mr. Dondero also is making decisions?
Yeah, and I think you can have more than one purpose, more than one person who are exercising domination of a company. And I think the best case for that is the Berisha case, which involved a situation much like this one, where it was essentially a second in command who was found to be an alter ego and an equitable owner of the company. And I'll just say on that, this isn't a case where Ellington is just following orders and is not benefiting from this. He's masterminding the 2017 transaction to shift money to Sentinel, and then he's siphoning that money out to himself through the fraudulent transfers that we're also separately seeking to hold him account.
Thank you.
Thank you, Your Honors.
You each have 1 minute on rebuttal.
Thank you, Your Honor. I just want to first quickly correct one place where I misspoke. Mr. Dondero and Mr. Ellington are the only members of the advisory board for Sentinel, but they are only 9% of the voting power.
90?
9% of the voting power for the overall entity, which the control was in a trustee that had 91%. But more importantly, it doesn't matter because Sentinel is important only with respect to the fraudulent transfer claim. And here I'd like to point out that both in Chung and Asti, if we go back to the question of the wrong, Chung is a lease with continuing obligations. So that's the reason why later domination was important. There was preventing the lease payments from being made. And in Asti, there were additional cars sold. So the transaction attacked the alleged alter ego was involved with. Otherwise, if UBS's position was right, any breach of contract is a continuing wrong, because if there's a breach of contract that's not satisfied, it's open forever.
just to follow up on the continuing wrong, this court in Henry against Bank of America, which is cited on page 10 of our reply brief, says that New York law, under New York law, the continuing wrong doctrine may only be predicated on continuing unlawful acts and not on the continuing effects of earlier unlawful conduct. Thus, where a plaintiff asserts a single breach with damages increasing as the breach continued, the continuing wrong theory does not apply. That's exactly the situation here.
But aren't they alleging that there is additional acts being committed? Not only are they not repaying the monies, but they're also using the monies for other purposes?
They are alleging the 2017 transfers are additional acts. But keep in mind that they're relying on the continuing wrong theory, not for the 2017 transfers, but for the $1 billion judgment that was based on the breach that took place on December 5th, 2008. The amount of that damages, the $1 billion, is the amount that was set on December 5th, 2008, with a prejudgment interest running from that date. And so the only way, there is one breach for that $1 billion, and that breach was in December 2008. There's no continuing breach simply because it hasn't been paid. If that were the case, the statute of limitations would continue, would not run. You'd be
But I guess
able
the
to.
question is there a statute of limitations proper? Because under Morris, piercing the corporate veil is not a separate independent cause of action. It's parasitic to the liabilities or obligations of the corporation. Sorry. So wouldn't basically the individuals who are subject to the alter ego liability just have to stand in the shoes of the corporate actor?
The judgment has a 20-year statute of limitations, okay, in the judgment. The question is who can be held liable for the judgment? And the only people who can be held liable for the judgment, since it's a breach of contract judgment, are those that could have been held liable for the original Knox transaction breach, or someone who is an alter ego of that person at the time of the transaction, the Knox transaction. In the case of Mr. Ellington, who had nothing to do with the Knox transaction, there's no way he can be held liable for the Knox transaction, for the $1 billion of ultimate damages on the Knox transaction, and it's not a question of statute of limitations, it's a question of underlying liability.
Thank you.
Thank you, Your Honor.
Thank you all. Back to the top of the calendar, Garrido v. 200 Lenox Avenue. Yes.
Good afternoon, Your Honors. May it please the court, Jack Lockwood for the plaintiff's appellants. The Supreme Court erred in granting Barrow Wine's motion for summary judgment. The special use of the sidewalk, which is conceded, defined plaintiff's path and diverted her to the dangerous condition, approximately causing her injuries.
Counsel, wasn't the use somewhat of a distance from where the alleged defect was?
I think you might be referring to the experts, the affirmation.
No, we're referring, I think my colleague was referring to the photographs.
Sorry, could you repeat the question again? Maybe I misunderstood.
The special use where the chairs are is a distance away from where the alleged defect was.
Correct, Your Honor. The special use is not on the defect. However, it diverted and created.
How did it divert? So in looking at the photographs, you have the chairs on one side, right? And then you have the middle area, and then you have the tree well over on the other side. So how does that impede or cause the special use, the chairs, et cetera, cause your client to have to change her where she's walking and walk in the crack?
I think the plaintiff explained this in her affidavit. She said that there were tables, chairs, potted plants, umbrellas that were on the right side, which was closest to the restaurant.
Right.
That there were basically 3 lanes on this sidewalk. The
Yeah.
far left lane was totally blocked by this tree well. The the far right lane was totally blocked by the
So there's that middle
special
portion.
use. And then the middle portion, the crack went fully across the entire width of that middle portion.
This is the same crack that she stated that she had previously tripped and fell on several times, and also that she had observed the crack on numerous occasions for several months, maybe 50 to 60 times.
I think I'm not sure she said she tripped over it before, but she said she certainly had walked past it. And she
Had tripped and
noticed it.
fell several times in front.
And I guess that would go to whether it was open and obvious and not inherently dangerous, which defendants aren't even arguing on this appeal. In any event, this shows that this wasn't inherently dangerous. The crack, the height differential was greater than 1/2 inch. Therefore, it was a substantial tripping hazard under the New York City Administrative Code 19-152. The Supreme Court really based the opinion on the expert, which was sort of used as a fact witness here. And the expert's conclusions were based on assumed facts that are contradicted by the evidence.
What about the photo that Ms. Lugo took, Ms. Garrido's wife? Doesn't that, at record 434, it seems to show that there's plenty of room to get around the crack?
I think if you look at 435 and to 437, it first of all conclusively disproves the expert's measurement.
But 434, just returning to that for a minute, I mean, are you saying that the other photos are necessary for context to understand 434?
I think that there's a lot of photos in here. However, the photos at 435 was specifically shown to defendant's witness, who said that that's what the configuration was like in September 2020. The expert's configuration was set up about 3 years later, after the crack had been fixed, and the expert merely says at 301 that it was set up as it would have been at the time of the incident, with some unidentified
When you
tenants.
look at the photo at 435, there appears to be a sufficient space for someone to go around this particular defect.
I disagree, Your Honor, that there's blockage on that far right lane on both
Where?
sides.
I'm looking at 435. Where would you say that there's blockage on it?
The photograph shows that there are tables and chairs on both sides of the tree well. If you look at the permit plans, there's only tables on one side. If you look at the way the experts set it up, there's only tables and chairs on one side.
Perhaps,
It is not an accurate depiction.
My colleague asked about the questions that your client's wife took. Those photographs also seem to also kind of cut against your argument that there was no clear path.
Your Honor, I think that to the extent that the photographs, and there are a lot of photographs here, that to the extent that inferences may be drawn from them, it is not our motion.
You were stating that these photographs on 434, 435, et cetera, that these were taken well after the incident. The excuse me, the photographs taken by your client's wife were taken almost immediately. I thought your client called her wife after the incident, and her wife came immediately and took photographs.
Your Honor, the photographs taken at 435 to 437, the one on 435 was specifically shown to defendant's witness, who said that's what it was consistent with the configuration at the time. The expert doesn't even take into account the fact that there were tables on both sides of the tree well here. And if you look at the permit plans at 294 and 295, you'll see that there are no tables, no chairs at all in that area. Our argument is that they created a choke point that she necessarily had to traverse this crack, that there wasn't enough, even if there was some residual space in the area of the crack closest to the door, she still had to maneuver through it because there was these blockages on either side of it. And her affidavit couldn't be more clear. I mean, she testified plain as day. The Supreme Court didn't say that it was a feigned issue of fact or that it's incredible as a matter of law, neither does my colleague on
Thank
appeal.
you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. Abid Bouyan for Respondent Baraween. I just want to clarify something for the record. Your Honor's question about the appellant potentially having tripped over the same defect many times, it's probably my fault for not using a comma in the statement of facts here. she testified that she had traversed, so this is on page, I just missed it. On page 5 of our brief, Garrido had passed in front of Barrowine where she tripped several times, meaning that she had passed over there several times. Not that she had tripped several times. She'd only tripped the one time, but she had passed there about 50 or 60 times before, never having had any issues, successfully maneuvering the sidewalk that she lives across.
The issue is, how was it, what was the configuration of that area at the time that she fell? Were there tables immediately to the left that prevented her from going around this particular defect?
No, Your Honor, and I think that question is answered, as my friend on the other side mentioned. My client was asked specifically with respect to the photograph, I think on the record 437, to the right of the dog bowl there, which we can't see there, and these are questions from plaintiff's counsel. What's there? And there's nothing there, and we know there's nothing there also. Because of the photograph at page 319, which shows the crack running the width of the middle lane of that sidewalk, and a brick wall on the other side of the adjacent
You're referring
sidewalk
to the
flag.
photo that was taken by your expert, correct?
The photos at 437 and 319 were not taken by our expert, Your Honor.
Well, 437 is cut off. You can't see, you don't see the brick wall of 437.
That's right, Your Honor. I'm not suggesting that you can see it. It's specifically in the deposition of my client. Plaintiff's counsel asked, well, what's to the right of here which we can't see? And I'm just correlating the photograph of 437 with 319. Unfortunately, there's a lot of piecing together that has to be done, but plaintiff is leaning into the photographs here. And I think if the court follows the photographs, the court will see that there is the sufficient clearance that the expert based his opinion on is undisputed below. There is no dispute about the sufficient clearance. Plaintiff never does measurements herself or retains an expert herself. These are all arguments for the first time on appeal. They are unpreserved, but even though they're unpreserved, we'll lean into the photographs because the photographs show that the fundamental basis of the appeal here is a misunderstanding of what the photographs show. There is sufficient clearance. The plaintiff has walked this same sidewalk dozens of times. 98% of the time she was able to pass through without having a problem here. So there's not a reasonable or probable likelihood that this defect, alleged defect, would have caused this accident. So, and if the court, my final photo exhibit here is, if the court looks at the record at pages 298 and 302, if the court holds them side by side, 298 and 302, the court will see that there's no dispute, of course, of Mr. Chen's conclusion, and then look from the plaintiff's perspective.
Well, these photos on 298, that was taken on April 20th, 2023?
298.
It says site inspection on April 20.
These photographs were not taken by the expert, Your Honor. These were the ones that were shown at the deposition of my client.
298?
At 298, that's right. It's also at page 436 of the record, Your Honor. And what I'm suggesting to the court is just if the court looks at that photograph on page 298 with 302. 302 is the one taken by our expert. 302 is a close-up and shows the sufficient distance of the sidewalk flags. Now, my expert didn't say that the middle column, the middle lane of the sidewalk is 18 feet. I don't think the court is buying that.
My original question was, we know that the crack does not extend to the other sidewalk flag. We know that. It stops in the middle. The question is, the configuration of the umbrellas and the tables and the chairs, were they occupying that furthermost flag, forcing the plaintiff to walk down the middle? That's the question.
The furthermost flag adjacent to, I see my flag, the light is red. May I answer the question?
Please.
To the wall, next to the wall.
There were
Next to
no
the
tables adjacent to the wall. And the photograph that the plaintiff's wife took shows that there was no table between the crack and the wall. And my client testified that that was so that everyone can pass through.
And those photographs that you just stated her wife took, are those the ones depicted at 436 and 437 of the record? 435, 436, and 437.
That is correct, Your Honor. And also the 320. That's correct, right? Yeah. Those were taken by the plaintiff's wife same day of I don't know the exact time, but more to the point, Your Honor, 322 taken together with these shows that there's no table, no chair next to the crack. And the crack is not in the middle of that sidewalk flag. It's towards the end. It's the furthest possible point away from the direction the plaintiff is walking in. So she had sufficient clearance. And the 18 feet, of course, is shown in the expert's report on the tape measurement. So it is not a figment of his imagination. Thank you, Your Honor.
Thank you.
Your Honor, the photograph at 340 or 434 shows no tables at all. Shows nothing on the sidewalk at all. It's not an accurate depiction. And her affidavit conflicts with that. If you look at the next couple pictures, you can see that there's tables and chairs on both sides of the tree well. In addition, defendant's own witness testified at page 215 that there were tables both before and after the planter. So they were boxing off each side, creating choke points next to the planter, which diverted her across the crack. And that's what she said in her affidavit. That's probative evidence. As we said before, the expert's affidavit is based on assumed facts that are not in evidence, and in fact contradicted by these photographs.
Counsel, just to get an issue out of the way, Barwine's the lessee here, of course, right?
Yes, Your Honor.
And so has no statutory obligation to repair the sidewalk, right?
Without more, no, Your Honor.
And you're not saying that the lease placed any obligation on Barwine?
No, Your Honor, they put the lease in, and we're relying on the special use doctrine, Your Honor. My colleague mentioned preservation. We argued specifically at 414 and 415 that the expert's purported reenactment of the configuration was not accurate, and that
You didn't argue anything about measurements below.
we said it was not accurate. The configuration of the chairs and tables was not accurate, and that the expert's opinions were speculative, which we explicitly argue.
Is that the same as arguing that there were no specific measurements as to the chairs as related to the crack, or the crack as related to the wall, et cetera?
The expert took measurements, that's not disputed, but the problem is that the expert was measuring the configuration that the expert himself set up three years later. And we don't even know how he set it up. We don't know who the tenant was that supposedly helped him. I think if you look at the permit plans, I think he set it up consistent with the permit plans, with the photos show that it wasn't set up that way. It was not. It was actually in contravention of the permit plans. Thank you, Your Honors.
Portland v. TPG Capital.
Good afternoon, and may it please the court. Robert Fischler for defendant appellant Apex Partners LP, which we refer to in the briefs as Apex New York to distinguish it from the European Apex entities that have been dismissed from this case and are not parties to the appeal. I hope to address two issues today. First, the plaintiff Cortland's failure to state a cause of action against Apex New York, and secondly, Cortland's lack of standing to sue. With respect to failure to state a cause of action, Your Honors, the amended complaint, which was filed after years of extensive discovery into every nook and cranny of this transaction, alleges two, and only two, specific facts against Apex New York: the name of its owner and its office address. That's it. That's it. Not a single allegation with respect to any involvement in the transaction at issue, let alone involvement that could conceivably support a alter ego claim, which this court described in its Max Marcus case as requiring the plaintiff to meet a heavy pleading burden. Given the absence of any specific allegations against Apex New York, Supreme Court should have granted our motion to dismiss for failure to state a cause of action. But where things went off the rails in Supreme Court is that Justice Reed did not focus on specific allegations against Apex New York, or more precisely, the absence thereof. Instead, what he did was to ignore Apex New York's separate legal identity and simply lump it together with the other defendants in the case, the so-called TPG defendants, none of which, by the way, are related to Apex New York in any way. And he assessed the allegations, the group pleading allegations, against all of the defendants as if they were a collective whole. That approach was fundamentally erroneous, and it led to a fundamentally erroneous result, one that is directly contrary not only to basic New York pleading rules, which require at least some degree of factual specificity with respect to every defendant, but also was directly contrary to this court's longstanding precedent in the alter ego context, expressly rejecting what it called in the Principia Partners decision the improper group pleading of alter ego claims, and instead requiring an alter ego plaintiff to allege particularized allegations against each defendant in a multi-defendant case. For all of these reasons, Your Honors, we think it's clear that Justice Reed should have dismissed Apex New York for a failure to state a cause of action. And if I could just very
How
briefly—
about standing? You want to talk about standing as well, right?
I do.
Okay, so Justice Reed found that the issue of standing was never previously decided, so collateral estoppel did not apply. Was that wrong?
Yes, it was wrong. The precise issue here on standing is whether Cortland's purported assignors had standing to sue at the time they allegedly assigned their claims to Cortland. This court, as well as Supreme Court, but this court addressed that precise issue in its 2016 decision in the case we call Cortland 1 in the briefs.
Yeah, the PIK case, I understand.
That's right. And the court held squarely against Cortland that the assignors, in affirming Supreme Court, it held that the assignors—
But there's a lot of water under the bridge since then. I mean, so Cortland was knocked out of the PIK case, right?
Correct.
Never
In the
brought
Pick-
back in. But there's
Bonderman or the Pick case, yes.
yeah, right. Cortland 1, let's call it. Okay.
Yes.
But there's been other facts have been uncovered. They acquired the assignments, they say. I mean, in other words, isn't there enough to get past the motion here?
No, Your Honor, and this is a critical point. They rely on something they call newly pleaded facts that they did not argue in Cortland 1. Those facts relate to these clearinghouse rules that they say supplied suit authority to the assignors, and then that the assignors then transferred that suit authority to Cortland when it made the assignments. But those procedures, and this is conceded, existed and were available to Cortland when it litigated Cortland 1. So simply pleading them for the first time does not avoid collateral estoppel. They could have and they should have argued exactly what they're arguing now when they litigated Cortland 1. I mean, otherwise, if you accept what they're saying, that they can, in effect, make a new argument based on old facts, and that's what this is, then you're in a situation where you would undermine the entire doctrine.
A new argument based on old facts, but with a new cause of action in this case.
Doesn't matter. Collateral estoppel says that if the issue in the case, in the current case, was decided in the prior case, and the plaintiff or the party against whom the estoppel is asserted had a full and fair opportunity to litigate that issue in the prior case, that is sufficient for collateral estoppel. Not only did Cortland have a full and fair opportunity to litigate whether the assignors had standing in Cortland 1, they took full advantage of that opportunity. They litigated the issue in 3 separate procedural contexts, which are described in our briefs: motion to dismiss, motion to amend, then again when they appealed to this court. And I would also add, parenthetically, that they litigated the issue in federal court, and they lost in the district court. They appealed to the Second Circuit Court of Appeals. They lost again. Cortland is entitled to its day in court. Nobody disputes that. But they've had multiple days in court, in multiple courts actually, already. And they
5 times
can't,
here at least.
Yeah, we're up to Cortland 5.
Yeah.
You have time on rebuttal.
thank you.
Good afternoon. Paul O'Connor for the remaining 7 TPG entity appellants and the 2 TPG-related individual and estate cross-respondents. Rather than focus on the arguments that are in my briefs, and as I pointed out, the case has been here a number of times. I know this court knows it well.
And I think to the Court of Appeals twice, right?
Indeed.
Confirmed twice.
And that's what I'd like to focus on this afternoon, actually, is that after the briefing went in this case, there was a decision from the Court of Appeals on this court's 2024 decision that threw out all of the claims against the TPG parties that were remaining in the Pitt case that has been referred to before.
This is from December 18, 2025?
That's correct. And it's been cited by this court already at least once by a number of members of this panel in the alter ego context. And what I think is important about that decision is that it really ultimately explains what's going on here. Again, the Cortland complaint that we're dealing with here, as Mr. Fischler has already pointed out, was amended after years and years of discovery, taken all around the globe. They could have put specific allegations in their complaint against the various defendants. They did not. And the reason they didn't do that is shown by this court's 2024 decision, tossing out the TPG parties from that case on summary judgment, and the Court of Appeals' unanimous affirmance of that decision in 2025, which points out that there are no facts that they can plead. There's nothing to say. All they can rely on are these generalized group allegations that they've been making against the quote-unquote TPG and Apex parties. They lump everybody together. Just like Mr. Fischler said as to Apex New York, if you look carefully at the complaint, you'll see that the 7 remaining TPG entity defendants in this case, there's not a single reference to any one of them on either of the prongs of alter ego. In terms of
in your reply
dominating.
brief, I'm sorry, Mr. O'Connor, in your reply brief, you were also, your first argument was about that we don't have the opportunity to even consider alter ego here because Luxembourg law applies. Isn't that right?
First argument that we made is that Luxembourg law does not recognize alter ego
And so
at
there,
all. But again, the Court of Appeals has now decided a decision under New York law in the Pitt case, which points out again, whether you're applying Luxembourg law, which does not recognize alter ego, on which they completely dropped the ball on, or alternatively apply New York law, where we've already prevailed. There just are no facts to plead, and that's why Cortland has done what they've done here. What they've done is they've taken a complaint after years and years of discovery and amended it and not put anything in there about any of the 7 TPG entities that are left in this case, all of which were amongst the 9 that were thrown out by that the claims were tossed on by this court in 2024, unanimously affirmed by the Court of Appeals in 2025. I'd like to get to that decision that the Court of Appeals issued because I think it's significant. Not only did they unanimously affirm what this court did in 2024, but
Well,
the
Chief Judge wrote a concurring opinion.
Chief Judge wrote a concurring opinion, exactly. I can turn the microphone that way. And I think what's important about what the Chief Judge did in that concurrence was he pointed out that not only did he join in the fact that there was no alter ego pled against any of the 9, now the 7 that are left here, but he also pointed out there was no fraud. He took a look through the offering memorandum and he basically said it explained exactly what happened. What was in that offering memorandum is exactly what occurred. There's no fraud here. There's just no case here, period, end of report. And again, you don't take my word for it. This case is exactly the same as the Pitt case. It's the same parties. It's the same allegation. The complaints are nearly identical. It's the same offering memorandum, albeit it says subnotes here. It said Pitt notes there. It's the same discovery record. It's the same experts. It's the same depositions. It's the same case. They've been. The only difference is the different tranche of notes. They've got the same parties in here, and they allege absolutely nothing on alter ego, on either of the alter ego prongs.
Well, he says actually that it has nothing to do with piercing, with bail pacing, that it's solely concerned with fraud, and that there was an absence of fraud.
What he said was there was an absence of fraud, but he did join in the opinion that affirmed the 2024 decision of this court, saying that there was
Yes.
no alter ego as well.
Yes.
But you're right. He focused on the second prong, on the fraud prong, but he did say in a footnote that he thought it was unlikely they could meet the domination and control element either, but he didn't need to address that because there was no fraud here, which I think is pretty significant. We've been arguing, Mr. Fischler and I have for years and years and years, that there's nothing to see here. Nothing untoward occurred. You now have the chief judge who, in the context of an appeal from a case that's the same as this, I'm saying it's the same. They've said it's the same. They have argued to this court and to others that the case that was up in front of the Court of Appeals is essentially the same case. It's the same facts. It's the same parties. It's essentially the same offering memorandum. It's essentially the same complaint. There's no difference between the two, and the results should be the same. And on rebuttal, I'd like to, if I can, I'd like to address the cross-respondent issue, two individuals who were dismissed for lack of personal jurisdiction. I'll deal with that on rebuttal.
On rebuttal, thank you.
May it please the court, I'm Karen Fish from Grant Eisenhofer on behalf of Cortland. In response to what my colleagues have argued, I'd like to point out that we are at the pleading stage. There currently is a note of issue entered in the trial court. Apex has already moved for summary judgment in the trial court. TPG's motion is to be filed within the next few weeks. We are here looking at the pleading, a pleading that my colleagues claim is identical to the pleading in the PIK case. So I'd like to just draw your attention to this court's decision from the PIK case from 2001, case number 2021-04782, reported at 215-82nd at 446 to 448. Justices Weber and Mendez were on the opinion. In that opinion, the bulk of the arguments that are raised on this appeal with respect to the pleading have been outright rejected. Is New York the proper forum? That decision says yes, it is, at page 447. Does Luxembourg law apply? No, it does not. Also page 447 of that opinion. Is alter ego adequately pleaded as to all defendants? That decision says yes, it is, at pages 447 to 448. Is the breach of contract adequately pled? Yes. Is this action barred by a no recourse clause? No, at 447, 448. So I just want to recenter the argument to the fact that we are looking at the pleading. And as the Court of Appeals held in its 2018 opinion, also in the PIK case, what might happen down the line, and down the line is already upon us in summary judgment before Judge Reed, is not part of the calculus today. That being said, I'd like to use my time on appeal to address the standing issue and to address the distinction that Judge Reed made between the Euroclear and the Clearstream custodians, because I think that that is the one part of the case where Judge Reed made an error, which is obviously incredibly important to my client.
Would you mind identifying for me, assuming that New York law applies, would you mind identifying for me what are the specific actionable misrepresentations underpinning the fraud claim?
Sure. The actionable misrepresentations underpinning the fraud claim are, one, that the CPECs would not be redeemed until such time as there was no other outstanding debt. My client held the outstanding debt. The other portion of the fraud was that the CPECs were characterized as equity within TPG and APACs, but the offering memorandum by which my client purchased the underlying subnotes stated that the proceeds from the sale of the subnotes and also the PIK notes would be used to redeem deeply subordinated debt.
So just stopping you there, doesn't the offering memorandum use those two terms, CPEC and, quote, deeply subordinated shareholder loans, equivalent terms?
I don't believe it does. I mean, a CPEC by definition is an equity instrument. There was no indication in the offering memorandum that the proceeds of...
It is described as an equity instrument in certain places, but it also, isn't it described elsewhere as debt?
Yes, I mean, I believe that I've heard my colleagues in the past argue that it's a hybrid debt equity instrument. But the point is that people purchasing the PIK notes and the subnotes, which my clients hold, would have no way of knowing that the proceeds of these offerings were going to pay off the CPECs, especially at the valuation at which they were sold. And another part of the fraud, which is actually different than the PIK case, is that with respect to the subnotes, the CPECs were actually held out as collateral for the subnotes. So this is the equivalent of, taking out a home equity loan and then going and selling your house. My client was told that the CPECs were secured by, rather, the subnotes were secured by the CPECs, and then the CPECs went and were redeemed for, 35 times greater than par value. These hedge funds received over 2.5 times a return on investment and left the bondholders holding the bag with nothing.
The offering memorandum talked about security in terms of a certain percentage of the total CPACs in existence at a time.
Yes, but again, the CPECs were redeemed. I did want to cover the Euroclear versus Clearstream issue. It is covered pretty comprehensively in our papers, but I'd just like to highlight that my clients did whatever the courts asked of them to confirm standing.
So you got a certificate of holding.
Yeah.
And that was not a statement. It was used to confirm a pre-existing obligation.
Yes, and I just want to make clear that in no way did the lower courts or the prior decisions collaterally stop my client from going and getting the appropriate documentation. There was a right to cure. We cured. We did everything that we were supposed to do. We actually started a proceeding before Justice Friedman, I believe. It's the CSR proceeding where we submitted an order to show cause so that Euroclear and Clearstream would have to provide us with the necessary paperwork that confirmed our right to sue. In exchange for the stipulation of discontinuance of those two actions, we received documents from Euroclear and Clearstream that confirmed my client's holdings and also confirmed their right to sue. The Clearstream document is at 935 of the record, and I know my time is up. I just like to read the language from it. CBL, which is Clearstream, confirms that Citibank N.A. and/or the beneficial owner is authorized to maintain proceedings against issuers, guarantors, or any third party. The present statement may be produced in the context of legal proceedings initiated by the beneficial owner. If that's not a confirmation of authority, even if it doesn't cite to some sort of operating rule of Clearstream, it certainly evidences the practice of Clearstream, who has no interest in pursuing these claims. They've got no beneficial interest in the underlying debt. And they're saying to the beneficial owner, here, I'm telling you, you have the right to sue, and you can use this in a court proceeding.
Thank you.
Thank you very much for your time, Your Honors.
On the standing issue, what you did not hear is any rebuttal of the point that the exact procedures that Cortland is relying on now to say that its assignors had suit authority at the time of the assignments was not in existence when Cortland 1 was litigated. This whole idea of we have cured standing is a head fake. This is not a cure case. According to their own theory, the assignors had standing while Cortland 1 was being litigated. There was nothing to cure. That's their theory. The point here is that a litigant, a party cannot litigate an issue in case 1, make arguments A, B, and C, lose in case 1, start case 2, and make arguments D, E, and F on the same issue when nothing has changed. And that's exactly the situation here. Otherwise, collateral estoppel would have no meaning. We'd be going on forever. What if they lost on D, E, and F? Then what do they get? Do they get to start case 3 and argue G, H, and I? If you take Cortland's position to its logical extreme, that's exactly what would happen. So the cure cases where beneficial holders later on received authorization from the registered holder have nothing to do with this case, because in those cases, it was understood that standing did not exist at the beginning of the case. What Cortland's own theory is here is that the Asinors had standing from the moment they acquired the notes. They affirmatively argued that in Supreme Court. If you look at Justice Reed's decision, he absolutely references that particular issue. And as a result, they're not allowed to raise for the first time in this new litigation an issue that an argument that was available to them and that they could have raised and should have raised if they wanted to in Cortland 1. We've cited a number of cases in our brief that stand for this proposition. Subsequent to the briefing, this court decided a case called Saunders at 237 AD 3rd 485. That's in April of last year, which again reaffirmed the point that a party cannot simply take facts that existed when the prior case was litigated and raise a new argument in the subsequent case.
Thank you, counsel.
I'd like to just pick up where my learned friend left off, talking about the 2018 decision from the Court of Appeals. We're a long way away from the 2018 decision from the Court of Appeals, which noted that the pleading that was in that complaint, which essentially is identical to the pleading in this complaint, was adequate for those purposes, which they said was specifically was pre-answer and pre-discovery. We are way past that stage in this case. They have had reams and reams of discovery and an opportunity to put something in about the defendants that are left in this case. They put nothing in about them other than to name them and say where their principal place of business is. They don't tie them to the alleged wrongdoing here, which, by the way, there is no wrongdoing here. And I would like to come back to what the Chief Judge wrote. And what he wrote in his concurrence is the offering memorandum disclosed exactly how the recapitalization would work, how the money would go where, and the risk associated with the transaction. So not only is the pleading inadequate, but they're complaining about nothing. No fraud occurred here. You cannot have an alter ego complaint move forward that does not allege how the defendants engaged in domination and control and the use of that domination to commit either fraud or wrongdoing. They don't have either one of those. And we know from the Chief Judge that there was no fraud here whatsoever. And I'd like to draw the court's attention to an opinion that it issued on January 27th of 2026, which actually cites to the Cortland case, which this court decided in 2020, which the Court of Appeals decided in 2025, and also cites to your case in 2024 favorably for the proposition that a complaint that contains only conclusory allegations, which is what's happening here, cannot stand. And again, that case will be very familiar, obviously, to Justices Weber, Higgett, and Michael, as you were on the panel that decided that case. That's this case, and this case cannot stand. And again, it wasn't addressed here, but there's no basis to overturn the personal jurisdiction dismissal of the individual, and the two individuals, one of whom is now deceased and represented here by the executor. Thank you.
Thank you. Thank you all. People v. Thomas Nicholas. Yes, whenever you're ready.
Good afternoon, and may it please the Court, Center for Appellate Litigation, for Mr. Nicholas. Mr. Nicholas's lawyer, the prosecutor, and the trial judge all made clear to Mr. Nicholas that they believed he should be given a chance to participate in the Willard Drug Treatment Program.
Now, what they made clear to him and what the judge made clear to him prior to the plea was that the court would recommend Willard. They would recommend that the defendant be allowed to enter the Willard program. It was made clear that that is not a decision which the court or anyone else can make other than the Department of Corrections.
Right, Judge, but what the court was representing to him is that their recommendation had any meaning by virtue of the fact that he pled guilty to an offense that categorically made him ineligible. This was not something that Docs was going to think about or weigh certain factors.
Who knew that? Who knew that?
The court should have known that.
Should have known. Did the court know that?
It does not seem that anyone knew or researched.
The only one who would, the only entity that would know that would be Docs. Docs would make that determination.
Well, Judge, it is clearly laid out in the criminal procedure
So
law.
what should the court have stated to the defendant? The defendant stated that he wanted Willard. His attorney stated that he wanted Willard. The court made it clear that all it could do was recommend that the defendant entered the Willard program. So should the court have stated what?
If the court or his lawyer had actually looked this up, which is clearly in the CPL that this is not one of the possible crimes that can allow for admission to Willard, it should have said, I can recommend it, but it will not be honored. That's
So why
fundamentally
recommend it? I mean, I'm not understanding. So why recommend it if it cannot be honored?
Absolutely. That is the problem in this case, and that's why the plea is involuntary.
So again, what should the court have stated? So you're stating that there never should have been any discussion as to Willard?
The court could have said, I can't recommend Willard because you will not be accepted based on this crime. It is clearly laid out in the CPL. It is not something that is based on whether it is not akin to a court saying you will have an opportunity to get out of parole, but that's the Department of Parole's purview, or that's their decision of whether you will get out. This is something that is clearly laid out in the CPL, and the prosecution concedes in their brief that he would not have been eligible.
When did the defendant learn that he was ineligible for Willard?
He was incarcerated up until his conditional release date. So I don't have specifics of whether it was conveyed to him, but it was put on the sentence and commit sheet. But anyone who can look at the CPL and CPL 41091 will see that this is not one of the specific crimes that is allowed to be entered into Willard.
So at any point in time, did the defendant have an opportunity to withdraw his plea, make a motion to withdraw his plea because he was not entered into Willard or was ineligible for Willard?
Judge, all I can say is that the time it took for our office to get this case is where we're in the posture now. I don't have any information of whether that was made to the trial court, but I think that gets to the issue with preservation. This is not just that Mr. Nicholas has, that there was an opportunity to object or that this is simply incorrect information. This is a misleading statement that when you are sentenced, you will be given this opportunity. That's why.
No, I disagree. That's not what the judge stated. I think he made it quite clear that it was not on him and was not his ability to state whether the defendant was going to receive Willard or not. He made it quite clear that it was up to Docs as to whether he would receive Willard or not. And you talk about the posture that we're now in. The defendant has completed his sentence. He is no longer on parole, so he's free in terms of any supervision or what have you. So why would we, under these circumstances, if we agreed with you that somehow more should have been told to the defendant or should be made clear to the defendant that he was ineligible for Willard, why would we dismiss the indictment?
Because, Judge, plea vacature is not going to remedy the issue here where he has served this sentence, where he has served 2 years of incarceration. And I think that in a case like this where Mr. Nicholas has a very, very minor role, there are still 40 co-defendants, several of whom had a much more serious role, remain prosecuted. And I think that given the involuntary nature of this plea and where he has served that sentence up to his conditional release date, that is the proper remedy for what has happened here. And I will save for rebuttal.
I think Justice Michael had a question.
You can save it for rebuttal.
Thank you.
Good afternoon, and may it please the court. Jelena Hudson from the Attorney General's Office on behalf of respondent. Defendant's challenge to his guilty plea fails for several reasons. First, the claim is unpreserved for this court's review, and no exception to the preservation rule applies. After failing to preserve the claim, either through a motion to withdraw or a 440 motion, he now seeks an even—
Counsel, when should the defendant have raised this, given that Willard, his eligibility to Willard would have been something that would have arose once he was incarcerated?
Well, Your Honor, the Court of Appeals has said in Williams that it's not about actual knowledge, it's about the practical ability to preserve the issue. And here he had almost 4 weeks in between his guilty plea and his sentence to research the issue, to ask questions, and to raise it with the court, especially—
Is it incumbent upon the defendant to do the research?
Well, either him or his defense counsel could have preserved it.
So the fact that the attorney apparently did not research it, would that not lead us to determine that the plea was not voluntary?
No, Your Honor. And also, I should say, it's not clear on the record what counsel was thinking. This case is very similar to People versus Peltzer in the second department, where at the guilty plea, he didn't know he was ineligible, but at sentencing, the judge said, you're not eligible for placement in Willard. And this might not be obvious from the case, but the briefs make clear, and I'm happy to provide the briefs in Peltzer to this court. Defense counsel said, well, Your Honor, there's still value in the recommendation. I'm still asking you to recommend it because
That's not
Fox
what
can
happened
consider
here, right? The judge said he would recommend him to Willard while he was pleading guilty to a crime that made him ineligible for Willard.
Right, but all he promised was to recommend him to that, and the recommendation still has value, even if
there was no, even if that recommendation was not gonna be carried through, regardless, because in reality, he's being misled to believe that he's got a shot at getting into Willard, even though it's only a recommendation.
He's not being misled, Your Honor. He was promised a sentence of
Was
1
he
to 2
told?
years.
Was he told that you don't qualify for Willard?
He was told you might not qualify for Willard.
But that's not a definite. You don't qualify.
And he did not qualify. On his criminal background, on its face, meant that he was ineligible for Willard.
He might not have qualified for the bench warrant reason either. That wasn't resolved by the time he pled guilty or he sentenced, or at the time of sentencing. And he was warned
But
you might
it
not
was clear
be
throughout
eligible.
the plea proceedings that Willard was an important component because the defendant continuously requested consideration to Willard.
He did, and the court continuously told him, I can't promise you placement, and I can't promise you that you're eligible. This bench warrant issue in New Jersey might prevent you from being eligible for Willard, and that hadn't been resolved.
But it's not a might. He was ineligible as he stood before the court having taken that plea. He was ineligible for Willard.
That's one of the reasons that he was ineligible. But
he
Your
had
Honor,
no knowledge of that.
we don't know from this record, again, what defense counsel might have discussed with him. This is still a very good deal. He was able to resolve 5 pending indictments across different counties, and he got the minimum sentence.
That's a different consideration as to whether this was in and of itself a good deal versus whether he was misled to think that there was a potential that he could get treatment through Willard as part of this plea.
I would still say, Your Honor, though, that the recommendation has value, even though the court promised him the recommendation and gave him that recommendation, and that's why his plea is valid. He received...
So recommending something that can never be actualized has value?
In this case, Your Honor, I think when Doc screens everyone, and Docs in this case saw that the judge recommended a program for him. This is a little bit off the record, but it's just an example. Doc said, well, you're eligible for shock incarceration, which you can still shave time off of your sentence after 6 months in shock incarceration. Because of the judge's recommendation here, Docs did offer him that, and he chose not to take it.
Do you agree that if we found that the defendant was misled and therefore his plea was not voluntary, that the remedy would be dismissing the indictment?
No, Your Honor. The Court of Appeals law is pretty clear from Conceição and several other cases that the proper remedy is to reinstate all of the accusatory instruments in this case because it wasn't just the resolution of this.
And how much time was he facing if all of these accusatory instruments are reinstated? How much time would he be facing?
I don't know what he would have been indicted for had those cases proceeded. They weren't handled by my office. I do know in this case he received the minimum, which was 1 to 3 years in prison, and maximum was 8 1/3 to 25 years.
Thank you.
I just want to briefly touch on the prosecution's reference to Williams because I think it ties into what Your Honors were asking. There's language in Williams about how the defendant has an opportunity to seek clarification, and that's exactly what Mr. Nicholas did here. On page 7 of the plea minutes, the court recounts the plea offer, I understand, is by pleading guilty to count 4. The people have offered you a sentence of 1 to 3 years incarceration. Is that your understanding as well? Mr. Nicholas says, no, I would do Willard. I didn't know about the 1 to 3. That's the clarification. And at that point, the court his defense counsel or the prosecutor, had they consulted the CPL, could say that's not a possibility, but this is what he is asking for. He seeks that clarification. The court says this recommendation has value, but it's our position that the recommendation is useless, given what Mr. Nicholas expressed about what he wanted to do and what he hoped.
Are you saying that that question there is preservation for this claim? Him saying, I want Willard and not one and a third?
No, sorry, Judge. What I'm saying is this is part of why it does fit into the narrow exception where preservation does not apply, as we laid out in our brief, because it's being misled. It is not that he doesn't have an opportunity to object or that the information is simply incorrect. He's being told this recommendation could mean something, and it will not mean anything.
Let's say we agree with you on preservation, and we agree with you on the merits, but we disagree with you that the remedy should be dismissal. Would you prefer we keep the conviction in place, or that we vacate and remand for further proceedings?
Yes, it was not clear in my brief, Judge, but to clarify, if the court is not inclined to dismiss based on an involuntary plea, we would ask for you to affirm the conviction and let it stand. We are not asking for plea vacature of the indictment. We are asking for dismissal, and we think given the involuntary nature here, given that this was a promise that could never be fulfilled, a promise that had no value, no use, and I think given Mr. Nicholas's very, very minor role in this offense, given all of the history in the PSR of what he was involved in for these, which are essentially petty larcenies that he committed several times, I do think dismissal is the appropriate remedy.
Thank you.
Thank you.
People v. Melshon Johnson.
Good afternoon from Mr. Melshon Johnson, Office of Appellate Defender by Christiana Prater-Lee. I'd like to focus today on the lesser included issue. I first want to clarify that for the excessive sentence claim, we're only seeking a year's reduction in his custodial sentence. He received the minimum PRS term. But in any event, Mr. Johnson's conviction must be reversed due to the denial of the lesser included charge of reckless assault in the third degree for the top count of intentional assault in the first degree, which is reasonably supported by the evidence that Mr. Johnson acted recklessly but not intentionally with respect to the risk of physical injury.
So watching the video, how would his actions constitute reckless behavior?
Yes, Your Honor. So the video shows that this was a chaotic encounter in which Mr. Johnson and Mr. Gilliard meet. Mr. Johnson, he has a knife, but there's two other parties that have knives and are slashing at his vehicle. Mr. Johnson and Mr. Gilliard, they're both gesturing wildly. You can see this in video. They're exchanging words. Mr. Johnson slaps Mr. Gilliard on the head, and you can see in the video that Mr. Gilliard approaches. He takes a step towards Mr. Johnson with his arms raised. It's at this point, and it's not clear in the video, but it's at this point in which Mr. Johnson jabs his knife towards Mr. Gilliard. Mr. Gilliard does not realize in the moment that he's stabbed. Everything happens so quickly that it's not until after the parties have calmed down that anyone realizes that Mr. Gilliard has been stabbed. And Mr. Johnson's testimony—
Mr. Johnson had invited Mr. Gilliard and Ms. Dover to come talk with him that night, is that right? I mean, he sent a video of him putting Ms. Dover's clothing on the ground and somewhere on 8th Avenue, and then said he wanted to talk to Mr. Gilliard man-to-man, is that right?
Mr. Johnson testified that he had no desire to have any sort of confrontation here, that there had been that text message, that there was, that he had thrown away the clothes, thrown away the keys, but he testified at that point that he had no desire to have any sort of interaction, that he was done with his girlfriend, that this was in the middle of their breakup dispute. And there had been testimony that there was going to be some sort of conversation, but Mr. Johnson also testified that he had no desire to have any sort of—
Well, he admitted that he had the knife. He said he knew the knife was sharp. He was in arm's reach of Mr. Gilliard. He jabbed it forward, aware that it would puncture his stomach, and it did, in fact, puncture his stomach. He thrusted it at Mr. Gilliard's abdomen. So again, how would that constitute reckless behavior as opposed to intentional behavior?
That is exactly the test here for reckless behavior, where we're looking at a reasonable view of the evidence that Mr. Johnson acted with an awareness that his actions might cause physical injury, but he
When
did
you
not intend to.
thrust a knife into someone's abdomen, that is not a conscious effort to cause serious physical injury?
He was testifying that as Mr. Gilliard approached him, he was trying to get him to back up. This is at page 319 of the trial transcript, that he never intended to harm him. He was just trying to get him back up.
So
And
by
this makes-
thrusting the knife in his abdomen, he was attempting to back him up.
And this is exactly the facts of the McIntosh case, where there was an encounter between the parties. The complainant was approaching the defendant, and he stabbed at him twice, but testified that he was trying to back him up to poke
Right.
him.
So we have, again, your client's testimony at trial. We have the video, which again perhaps shows something other than reckless behavior. And then we have the testimony of the medical expert who stated that the wound penetrated to the back side of the abdominal cavity and injured several internal organs. So that seems to be more than just backing up. That seems to be a powerful thrust to the abdomen.
And the extent of injuries here is not dispositive. I point this court to Ryan and Akbar. In Akbar, there was a slash to the throat, a stab to the abdomen, and that was found to be still sufficient to give the reckless assault and third-degree charge.
Right, but the issue in terms of the reckless versus intentional is the possibility of injury, of serious physical injury. So taking all of this together, again, would that not lead to the conclusion that it was an intentional act, intentionally intending to cause serious physical injury as opposed to reckless?
Not at all, Your Honor. In the light most favorable to Mr. Johnson, his actions in trying to get the complainant to back up, where the extent of the injury is not dispositive. Ryan and Akbar both say that the extent of the injury is not dispositive. The facts of the
What
Ryan
happened to
case-
Mr. Gilliard?
Mr. Gilliard had, when he lifted up his shirt, he saw that
Did he ultimately, he died, right?
he died for causes not related to this a year after this incident, but he was not around for trial.
Thank you.
May it please the court, David Crowley for respondent. On the lesser included, I'd like to start by pointing out the claim is not properly preserved. Below, counsel simply said he did request the lesser included of reckless assault 2 and reckless assault 3. He prevailed in getting reckless assault 2, and the court denied reckless assault 3, saying, I don't think there's any view of the evidence that the injury was not caused by a knife. She then asked if counsel had anything else to say on this, and counsel said, nope, I have nothing more to say, and there was nothing else in my email. The argument they're making on appeal is not there was a reasonable view of the evidence concerning whether the knife was the source of the injury. What they're arguing on appeal is that there was as I understand the argument, there was a reasonable view of the evidence that the defendant was reckless as to physical injury, but not serious physical injury. You can search the transcript. You will never hear defense counsel explain that to the trial court.
I thought the argument was also that it was some type of a frantic melee, and that he's just swinging the knife and he's trying to back him up, and therefore it's reckless in terms of his just reaching out with the knife, as opposed to any intent to cause serious physical injury or physical injury.
Right, so that is part of their argument. I think it was their argument as to why he wasn't guilty of an intentional assault, and they prevailed at trial. I think I'll say two things. One, factually, and some of these questions emerged, the defendant did not, happen himself into a chaotic situation. I think some of the questions were exploring this. He took a number of acts to provoke his girlfriend. He stole her clothing. He laid it out on the street. He testified he was very agitated. And he waited for about 30 minutes with a knife, waiting for his girlfriend and her sister and Mr. Gilliard to arrive.
And the girlfriend and the sister also had knives.
They came up, they had knives. They the girlfriend starts attacking the rental car, defendant's mother's rental car. There's some brief words exchanged with the girlfriend's sister, but then she goes about messing up the rental car as well. And then defendant sort of wanders over to Mr. Gilliard's car, and he and Mr. Gilliard talk for maybe 5 seconds very calmly. There's no aggressiveness on either side. The defendant starts to walk away, and Mr. Gilliard takes a couple steps towards, a little bit more, and then just stands there, no weapon, nothing. And the defendant abruptly turns around, hits him in the head, and stabs him in the stomach. It makes no more sense of him trying to back him up than if I turned around and stabbed someone here and saying, well, I was just trying to back them up, right? I think there was compelling evidence that it was an intentional assault. But even if we're wrong about that.
Well, the jury acquitted.
Correct. Even if we're wrong, the question then becomes, for the purpose of the lesser included analysis, whether when the defendant, let's say he was simply trying to back him up by punching him in the head and I don't know what. I mean, the video shows he is pushing his knife at the victim, right? So there has to be a view that when you take a blade that's 4.5 inches long and you thrust it at the stomach of somebody, that you are reckless as to, you think, well, I may hurt them, but I'm completely unaware of the fact that I might really hurt them, right? Which is basically the test. Now, it may be conceivable. There may be a case like Akbar. On the other hand, there's a case like the Court of Appeals in Rivera, which says, in these sorts of facts, you shouldn't even get the reckless lesser included. But under all circumstances, you have to look at the evidence. Rivera makes clear, the Court of Appeals decision, it cannot be sheer speculation. And you will find nothing in the record, right? The defendant, we have his grand jury testimony. He never says, wow, I never realized I could hurt him so badly. He just says, I didn't mean to hurt him, right? But he admits he had a knife and he jabbed it at Mr. Gilliard, right at his stomach. And so I think, as many cases we cite in our brief, normally that's enough to show an intent to cause serious physical injury, because it is common knowledge that when you stab a dangerous sharp blade at someone's vital organs, there's a real risk that you could kill them. The medical testimony in this case supported that. And there is simply nothing in any of the evidence that emerged that would support this distinction, right? That would allow to find a reasonable view of the evidence that the defendant was consciously aware of the risk of physical injury, but not serious physical injury. And if
In terms of excessive sentence?
Excuse me?
In terms of excessive sentence?
So in terms of the excessive sentence, I now understand that they are not arguing for a reduction of the post-release supervision, which I think he received the only lawful sentence. The defendant nearly killed a man whom, according to his own testimony, he had never met before, who had never caused him any problems. And he did so after provoking his girlfriend to come down and because he was agitated at his girlfriend. This was completely senseless, unjustifiable in every sense, legal, moral, pointless, and that alone would be worth more than 1 year. But he also had 7 prior felony convictions. One of them was violent, which is why he's the second violent felony offender. And he had misdemeanor convictions, including assault from a few years earlier. Some of his criminal history included a sentence of up to 6 years. So substantial incarceration, in this case, just 1 year above the minimum, was warranted for this conduct.
Thank you.
Thank you.
Respondents applying the wrong test for the reasonable view of evidence. The reference point in terms of what the evidence must be reasonable to is the assault in the first degree. It's not, as respondent is trying to do, the intermediary second degree reckless assault. That's clear in the statute that it has to be in reference to the count in the indictment. So here the test is whether or not there's a reasonable view of the evidence that Mr. Johnson was aware of the risk of physical injury but did not intend to cause serious physical injury. And given his testimony that he was trying to get the complainant to back up, that he was not trying to harm him, in the light most favorable to Mr. Johnson, based off of the video evidence, there is that view. As far as preservation, counsel did clearly preserve this issue. Not only did he request under the reckless subdivision, the reckless third-degree assault, he relied on People v. Ryan, the case that we were just discussing, and he explained to the court that that case had remarkably similar facts. The facts in Ryan are on par here. In Ryan, the court decided that the third-degree reckless assault should have been given, where there had been a fight over a game of beer pong. The defendant, after the fight dissipated, went, punched the victim. There was a dispute between the parties, and at that point, the defendant in that case, he stabbed the victim one time, and the victim lifted his shirt later and saw that his guts were hanging out. That is what happened here. And just as the court in Ryan gave the reckless third-degree assault charge, it should have been given here. As far as Rivera, upon which respondent bases much of his argument, that case, the Court of Appeals found there was no view of recklessness based off of the undisputed expert testimony in that case that the three locations, the three stab wounds were inconsistent with the defendant's theory. The one wound here was entirely consistent with Mr. Johnson's theory that he had, in an effort to back up the complainant, stabbed him one time.
Thank you. Thank you both. Breeding v. High Hopes. Yes.
Good afternoon, Your Honors. For the appellants, Kevin Abrazis, may it please the court. The trial court erred in finding tribal issues under both the New York State and New York City human rights law. Even if we accept the plaintiff's allegations as true, the conduct she describes is not actionable under either statute. It is episodic, it's separated by long gaps in time, it's not gender-based, and critically, the majority of the alleged acts occurred during periods when there was no employment relationship and there was no work environment at all.
How do you define employment relationship in this context? Just when she's filming or when she's also promoting the film and going to the film festivals?
So I look at it as after the second filming ended, there was no control over the plaintiff. Everything was voluntary. There was no contract. There was no pay. My client didn't organize any of the events that the...
Wasn't she required to somehow promote this film?
Yeah, wasn't, excuse me, wasn't she required to do publicity for the film?
She was not required to do that. That was her subjective belief. There was nothing in the contract or no mandatory statement by my client to her that she had to do promotional activity.
Did he invite her to appear with him at certain festivals to do promotion for the films?
Well, yes, he did. He did say it would be nice if you would come as a team, that we all have this mutual interest of promoting the film, but it was not mandatory. And she made it sound like it was a condition of her getting another job in another movie. And he clearly said to her, even if you don't do that, you still have the part.
And the hostile work environment?
Under the hostile work environment, this does not rise to severe or pervasive under the New York State human rights law. The past precedent is clear that most importantly, it's not a work environment.
I'm sorry, most importantly, it's...
There's no work environment here. It has to impact the work environment.
Well, that's why I was going to, again, as my colleague had asked you, the employment relationship, what's the work environment? Is it the set where they're filming?
Well, there can be out of work activity. Like you go to a dinner, you're invited to a dinner, you go, something happens. But in all of the cases that are cited, there is an actual work environment. The boss will invite you as for a business meeting, and it could have an impact on the work environment. But here, the work environment was over.
But the allegation is that certain statements were made by your client at the Long Island Film Festival or something, that certain statements were made there concerning her actions during the filming of the movie.
Yeah, but again, that was not part of the work environment. That was not organized by my client. It was a film festival that everybody was invited to, and she voluntarily appeared for her.
Well, she was nominated, right?
Well, yeah, she was nominated, but she also had an interest. There was a balance of power here. She had just as much right to do anything after the film as he did. He didn't control her. There was no duties. She had no schedule. There was no obligations. It was, and most importantly here is the fact that her whole claim is based on a personal animus. It's not based on gender. Her whole complaint says that this case is based on the fact that we had a
Counsel, let
disagreement.
me just jump in here because she was terminated, right, from High Hopes 3, the third.
Yes, which happened in 2019.
Right. So that happened after he used some fairly gendered slurs, no?
No, the slurs came after she was fired because he was upset that he asked her to come on certain dates, and she then said, I'm not available because I'm not feeling well. But she also said that the reason why he fired me is because I didn't perform the scene in the first film the way he wanted me to do it. So in allegation 25 of her complaint, she states right there, this is based on personal resentment. It's not motivated by gender. This case is not motivated by gender at all. It's based on him being upset.
He called her a prima donna. He said that she was not Jennifer Aniston. I mean, those things
Yes.
sound gendered to me. I don't know.
Yes, but not on this record.
When did he call her prudish?
He called,
Expletive.
he called her those words, and on this record, the reason why those are not motivated by gender is because she told us that this is personal resentment.
No. When did he make those statements?
When he testified, he said he didn't even recall making this.
But the point was, didn't he make those statements to others? It wasn't only to her, but didn't he make statements to others who were in the industry?
No, not that I'm aware of. I don't recall that being.
I thought he had also made statements at the film festival.
Well, there's allegations that statements were made about her failure to perform the kiss in the first scene.
Yeah.
But again, I would agree that this may be for a jury that can look at this and say, yeah, those statements are regarding women. This could be motivated by
There was a
gender, but
group text. I think there was a group text where he apparently made comments about her, right?
No, not about her. Not about her.
That's when didn't he start spreading sexual rumors about her, and that's when he alleged that she was a prima donna and a prudish expletive?
No, that was a rumor. She says it's a rumor, and she supported nothing with that. And the court, again, I'm not disagreeing over whether or not I'm not re-arguing whether or not those statements were made. That's certainly for jury. What I'm arguing here is she admitted that this is not gender motivated, that this is personal resentment. That's what I'm arguing. I just want to be clear that we're not relitigating the facts. We're saying that this case should be dismissed because of her own statement that this is not gender motivated. This is based.
You have time on rebuttal? No. Thank you. You do, I'm sorry. Yes, you do. Yes.
Good afternoon. May it please the court. My name is Cleela Arrington. I represent plaintiff respondent Kathy Briding. And I think my colleague just articulated why this appeal should end. This case is rife with questions that are for a jury. This case, several of the claims that my client brought were already dismissed at summary judgment. We do not contest the lower court's judgment on that. However, we do believe that this judgment was correct.
But with regard to whether this is gender-based versus personal animus, how do you respond to that?
I would tend to agree with my colleague that that is a question for the jury. The defendant in this case did us the courtesy of putting a lot of his gendered slurs in writing. The testimony, and I would also say that the incident in question was my client's refusal to perform a scripted kiss, which at one point, perhaps that could have been personal animus, her failure to take direction, at which point he could have fired her there, then and there. He didn't do that. He persisted in attempting to physically force her to kiss him, to perform this kiss, and then continued to go on a 4 or 5 year tirade against her, documented in text messages, during which he called her a series of gendered slurs. They may have worked it out at one point or another. He did hire her to be in the third installment of his film series, but ultimately.
And based on your argument, some of the slurs that we've already reiterated here are, in your argument, gender-based.
Correct. I do believe the popular one, starting with a B, is very much gender-based.
What is your counter statement to your friend's arguments as to the dismissal of the hostile work environment and also retaliation claims?
I would argue that whether a work environment existed during that time period is another question for the jury. We only have the defendant's word that my client's attendance at these film festivals was voluntary. She said it was not. In fact, my colleague even called her testimony on that her subjective belief. And I believe that is very much signaling that a jury should determine whether that belief was subjective or objective.
Retaliation?
As to the retaliation, I believe it's also set forth in the text messages.
So is it the retaliation for not hiring her or terminating her for High Hopes 3?
I would say I would say over the period, the conduct was not only gender-based, but it was in retaliation for the initial 2015 incident regarding the scripted kiss. And again, it is over.
What was the protected activity that she engaged in that underpins the retaliation?
We would argue that the conduct after she refused the kiss, his physically attempting to force her, and her moving away from that, physically rejecting it, was refusing sexual advances, which is protected activity.
But in terms of the retaliation?
In terms of retaliation, I think his behavior over the next 4 years could be read to be retaliation for that. He did us the favor of putting it in writing. He referred to it again and again and again.
Was your client replaced in the High Hopes series?
Ultimately, yes.
Was it by another woman?
It was.
And what is that material in any way, shape, or form to the gender-based discrimination claim?
I would argue it is not material as, again, we have direct evidence. We don't need to infer anything from the defendant's behavior. He put it in text.
Your client was unavailable, I thought, for shooting. They changed the schedule at some point in time. She was scheduled to do it, then they changed the schedule, and she said that she couldn't do it because she was doing something else, right?
She was the female lead of the film. The fact that he specifically chose to change the scheduling of her date, I believe a jury could find.
I thought it was because that there was another issue with somebody else, which was why they changed the dates, which she was already committed to do. But your client, was committed to doing something else.
That was the defendant's testimony. I think you'll see in the record that even he contradicts himself several times over the course of the record. We do not find it to be credible. We believe that we should have the opportunity to argue that to a jury.
So I just want to get back to the retaliation again. My colleague mentioned the protected activity, but also what was the adverse employment actions based upon her, based upon the activity? Is there anything there that she wasn't able to secure other roles, or was it only that she was ultimately unable to reprise her role in High Hopes 3?
Well, I think the most obvious one is her inability to reprise her role, but the record does show, or my client did testify, that she believes that Mr. Pillier's conduct towards other members of the independent film community did affect her ability to get further roles.
Thank you.
Thank you.
I'd just like to address the point. I think they did say that this was about personal resentment, which is our argument here. We're not disputing that some of the words are gender-related, calling someone those names. If we did not know specifically from them telling us that this is all a result of personal resentment, would definitely be okay for the jury to decide what the motivation here was.
But we can have mixed motive cases, right?
Not here, not on this record, because they told us that this is because of personal resentment. There's no objective indication here.
But
that
the question is whether you can have personal as well as gender-based motivation.
Not on this record, because they told us what this is about. They said this is personal resentment. So we can't have two motives.
Okay.
Counsel, just one last thing. Are you asking us to infer no discrimination because another woman was hired for a role that was described as a cis woman?
Well, that's one factor.
Why? And that's the only person who can, the only gender who can fit in that role in this movie. So how is that showing non-discrimination? Of course you're going to get another cis woman to work in that job. She's playing his wife.
That's not the main reason. The main reason here is that their own admission is that she says the reason why I was terminated is because he was still upset that I didn't perform the scene the way he wanted me to perform the scene. He disagreed with her for the reason why she wasn't doing. She agreed to do the scene. It was written into the script. He was advancing at a character. He wasn't advancing at her. He wrote the movie. He was very upset that this scene was not going to be performed the way he wanted it to be. And when she said, I'm not doing it, they ultimately changed the scene for her, and they did a hug. And they continued, and everything was fine.
But he never let it go, according to her.
Right, so everything
never
was
let
not
it go.
fine.
And he also continued to mention it because, again, he mentioned it at the Long Island Film Festival. Thank you both.
Thank you.
Clemente v. City of New York.
Good afternoon, Your Honors. May it please the Court, my name is Chelsea Hill on behalf of Petitioner Appellant Joshua Clemente. Having found that Mr. Clemente was wrongfully terminated in violation of the civil service law, the lower court erred in failing to award him back pay, benefits, and other related benefits of employment.
The lower court said he was entitled to a hearing concerning his termination, right?
Correct. But he is entitled to that hearing pre-termination under the Section 75 of the Civil Service Law. And so he is entitled to that hearing as a matter of the law, not as a remedy to his wrongful termination.
Well, how do we make a determination as to whether he's entitled to back pay if there's no determination as to whether he was wrongfully terminated?
So if he is entitled to a hearing, he was wrongfully terminated. So the hearing under Section 75, under the plain language of the statute, because he's a public employee, he is required, who has served more than 5 years in a non-competitive title. This is specifically Section 75, 1C. Because he meets those criteria, he is entitled to a hearing before termination. It's a due process protection that's created by the statute. I'm sorry?
Aren't there exceptions, though, in terms of termination?
If they meet the criteria to qualify for Section 75 of the statute, my understanding is no, they cannot be summarily terminated without first having a hearing or having a due process with the ultimate step being a hearing. You know, things can settle before that point, for example.
So the determination was that a hearing was required, but not that he was wrongfully terminated.
Correct.
And once the hearing is conducted, then the termination issues will be decided along with the back pay.
So the termination was wrongful at the time that it occurred because he's required to have a terminate based on the plain language of Section 75. He's required
So you're saying
to have
because he was terminated without a hearing, then he's automatically entitled to back pay?
Correct. Because he could not be terminated at the time that he was, the remedy for that, the way that you make that violation, make him whole for that violation of his civil service rights would be reinstatement along with back pay, and then for him to be provided with the hearing.
Well, isn't it that he would be entitled to a hearing where termination would be determined in addition to back pay?
So,
as I read the statute.
Right. So
the statute doesn't say that if he is terminated without that hearing, that in and of itself is a wrongful termination. It just entitles him to a hearing.
Correct.
And it doesn't say that he would automatically be entitled to back pay.
Well, so then I would also draw your attention to the case law that we've cited in our briefs. You know, based especially in our reply brief, we cite several cases involving specifically public employees who were terminated without their full due process rights. And the courts in those cases uniformly held that wrongful termination in violation of the civil service statute is remedied by reinstatement and back pay, and then the ability to have your due process hearing fully. At which point, you know, the employee can still be terminated. It's just that in order to remedy the wrong of terminating the employee without giving them due process, reinstatement and back pay are the remedies for that, because they have to be reinstated and brought back in order to then be an employee again, to go through the employee discipline and termination process.
Doesn't that process include some, in quantifying back pay, say you're due back pay, you also have to quantify offsets in case the employee had some work that he was able to get in the period?
Yeah, that is correct. And that would be obviously a matter for a later hearing or determination.
It could be conducted during the same hearing, could it not?
So our understanding of Section 75 is because Section 75 necessitates that someone still be an employee. It's, again, a pre-termination hearing. There is no part of the statute that allows a judge in a Section 75 hearing to award back pay, based on my reading at least. And again, some of the case law that we cite says that an Article 78 proceeding, which is what this appeal is here from, is the exclusive remedy, the exclusive avenue to obtain reinstatement and back pay, specifically Austin v. Board of Education and Village of Northport v. Krumholtz.
Your reading of the statute is therefore that if once a hearing is conducted, if it's determined that he was properly terminated, then there would still have to be another hearing to determine back pay?
Well, so once we go to the Section 75 hearing, they can determine that he can be terminated, but that does not make his termination as of October 17th, 2024, before having that opportunity to have his full due process and this hearing. That does not make that termination justified. That is still a wrongful termination that must be remedied by, again, reinstatement and back pay. And then the ultimate decision that he can be terminated is a separate hearing altogether.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for respondents.
So is that your understanding or your reading of the statute?
It's not at all, Your Honor. I mean, I think that then there's a number of cases that we cited, including from the Court of Appeals and this court, that do talk about the fact that on the hearing, even if you are, if the charges are sustained, if you're found guilty of the misconduct, and as I think your colleague pointed out, there hasn't been any determination on the merits here. I mean, there's an internal investigation that determined that the petitioner was falsifying time records.
But do you agree that there should have been a hearing to make that determination?
We have not appealed the aspect of the Supreme Court's decision that directed the hearing.
Okay, so there's a hearing that's held. The hearing determines whether there's basis for termination.
Correct. And
what's the next step?
The statute does provide that if a petitioner is exonerated, he is put back in his position. And the statute actually does provide in those circumstances for, I believe it applies for back, it has a provision for back pay.
So if there's a determination, but if there's a determination that he was properly terminated, or there was a basis for his termination, then is he entitled, is there another hearing now that's conducted to determine whether or not he's entitled to back pay from the date of the determination at the hearing to when he was wrongfully terminated?
I don't see why you need to have a separate hearing. I mean, certainly there is judicial precedent that we cite in our papers that says that even if you are found guilty of the misconduct and it's upheld, you are still entitled to back pay for a period that exceeds a 30-day unpaid suspension, less offsets for potential other employment, and plus you also any offsets for a period of delay that might be attributable to the petitioner.
Thank you.
Just quickly, Your Honors, I would differentiate the case law that the city has cited in this case. The cases in their brief all involve situations where an employee was suspended pre-hearing, not terminated pre-hearing. This pre-Section 75 hearing, excuse me, to be specific. So again, so we're seeking back pay in this case because it is the remedy to wrongful termination, and thus required to make Mr. Clemente whole for the violation of his due process rights.
Counsel, what exactly are you asking for here? We're saying, it sounds like your opponent's agreeing, go back to a hearing. You want us to quantify the back pay that you're...
Not to quantify the back pay. I do understand a record needs to be made to come up with that number, but the lower court, simply ordered that Mr. Clemente have a hearing, which he is already entitled to under the law, and again, does not remedy the fact that he was wrongfully terminated and could not, under the civil service statute, be fired at the date that he was back in 2024.
So what do you want us to do?
We want you to, we would ask that this court reverse just the lower court's decision to the extent that it failed to order those additional remedies of back pay, seniority, and other benefits of employment, and leave intact the part that requires that a hearing be held.
But you do agree that a hearing would have to be held as to the calculation of the back pay, et
Correct,
cetera?
but that is based on, my understanding of the case law, that is properly part of the Article 78 process and not the Section 75 hearing.
Thank you.
Thank you, Your Honors.
Thank you both. People of the State of New York v. TikTok. Whenever you're ready.
Good afternoon, Your Honors. May it please the Court. John Hacker for Appellants TikTok, Inc. This appeal is not about the deception claims asserted by the state pursuant to its recognized authority under traditional consumer protection statutes. It is only about the state's effort to invoke the blunt instrument of product liability law to attack third-party speech compilations that are protected
But
by
isn't it a product? The TikTok itself, is that not a product?
No, TikTok is a
The algorithm.
platform. The algorithm, that's all a publication mechanism, a service under New York law compared to a product. There's some states where service has a specialized meaning, but here it's in fact, the platform is called under the federal statute, Section 230, an interactive computer service, right? So it's a service, not a product. A product is generally regarded under.
So the algorithm itself that feeds information to people, that's not considered a product.
Well, it wouldn't be a product because nobody's purchasing that product, right? You're not, that's not something that's sold. That's the thing that's used to
Does
provide the
something
service
have to be
of
sold to be a product?
Yes, that's commercially distributed under
That's
the
that's the definition of product?
It's a tangible item that's commercially distributed. That's the third restatement definition. So it's not something that anybody is acquiring or
But it was developed by TikTok, right?
Absolutely. And the fact that, services are developed by a service provider, as profit-making mechanisms, that's not what qualifies something as a product. It has to
Is it a service that a TikTok user could opt out of?
Well,
The algorithm.
yes, you don't have to do the For You feed. There's other
don't have
things,
to
there's
do
other
that.
services. The For You feed.
Well, I guess that's why we're here. The state is saying that it is addictive, and therefore, once one participates, particularly children, that they become addicted, and therefore the ability to opt out is at least hindered.
Yeah, which to me doesn't go to the question of whether it's a product or not. It goes to the underlying question whether or not they can regulate this speech compilation, which is unambiguously a protected speech itself. It's
Well,
published.
what does the First Amendment protect? Human beings or artificial intelligence?
Well, it applies fully to corporations that are speaking. And what the rule of speaker's autonomy, we know from the Hurley case, means is the government doesn't get to conduct an investigation into a speaker, whether it's a person or a company, to figure out how they have decided to select, in the case of a third-party compilation, the different third-party content that's going to be put together. I find it chilling, the idea.
This is a little different, right? Because you're gathering together things based upon the user and what the user has exhibited some interest in, and then feeding that directly to the user.
So
it's not like you're collating or gathering together speeches, right? Like, let's say, someone likes speeches from, history, and you're gathering together certain historical speeches. No, it's what the person has exhibited an interest in that the product pulls together,
So
and feeds to the user.
So a couple points. First of all, it's still a compilation of speech. That's absolutely just like an anthology, but it's done at scale in a more targeted way to more users than an anthology can do. And the fact that it's not, presidential speeches or a nature anthology doesn't change the fact.
Well, what
that
about the TikTok shop, right? Because the TikTok shop is based on algorithm and what a person clicks on in their shopping history to sell products to that person that person's interested in.
Yeah, the products that you're selling would be products. This is about the speech. They're attacking the speech compilation, right? It's like an anthology, but it's on a computer platform. And we know that the First Amendment rule that applies to compilations applies by its terms here. Here's what the Supreme Court said in Moody. Deciding on the third-party speech that will be included or excluded from a compilation and then organizing and presenting the included items is expressive activity of its own. It is up to the speaker itself to decide what criteria the speaker is going to use, what mechanisms.
There's a flavor in the complaint that's like you're taking away their cognitive liberty almost, like you are making them addicted to this material and you're impairing their neuropathy, or I'm using the wrong word, but like in other words, the way they use their brains, that it's changing how people are able to think, concentrate, et cetera. So
especially children who don't have executive functioning yet. I mean, there are adults who don't have that, but.
Right, so I would say that is no different in kind or qualitatively than the kind of attacks on speech that government has made time and again, including, for example, in the Brown case. The Supreme Court decided it was about violent video games. And it was targeted because the state's argument was violent video kids are harming kids in particular, and the Supreme Court said that's not a basis for speech regulation.
What I don't understand is, it seems to me that you're trying to have it both ways. On the one hand, you're not responsible for the content of the algorithms. You're just sending it out. But on the other hand, you're stating that you're protected because under the First Amendment, free speech. So do you control it or do you not control it? And if you don't control it, then there's no issue as to the First Amendment.
Right, so a couple of points. As the Patterson case from the Fourth Department said, it's not that we're trying to have it both ways, it's just that the First Amendment and I think you're referring to Section 230 both apply to this conduct. They both protect different elements of the conduct, but they both apply. The First Amendment applies because the compilation
in
is a speech.
Patterson and in the subway surfing cases that we've seen so far, the challenge is to the particular content of speech, right? So in the Patterson case, it's hate-fueling speech designed to radicalize, particularly like young white men against individuals of color. In the subway surfing case, it's content relating to subway surfing. Here, as I read the state's complaint, we're not challenging any particular content. What we're saying is the design of the algorithm itself is such, regardless of the nature of the content, that it fosters and then maintains dependency on accessing TikTok material, whatever that material may be. And so it seems like we're in a different realm than we were in Patterson and the subway surfing cases. The challenge, at least somewhat facially, is content neutral.
So that's about Section 230, and that's what I started with was the First Amendment, because the First Amendment doesn't ask that question. It's not about specific content. It protects the compilation as a compilation. That's the lesson of Moody. If the compilation is its own distinct speech compiled from third-party speech.
But there are allegations in the complaint around specific design features that are created to push particular types of information to young people.
But the other way to put that is to make the compilation, to say to when a user comes on and says, what entertainment will you provide me? What entertainment do you think I will find engaging? And TikTok answers that with its message. These are the things we think you'll find engaging, informative, and entertaining.
That's the whole point, is that with the algorithms, I did not ask for that information. Many times I have not asked for that information. It comes to me unsolicited.
No, but when you go onto TikTok, what you're looking for is entertaining and informative videos. You're literally asking it by opening it up.
Yes.
What will you provide me? And am I going to find this entertaining, interesting, informative, engaging?
Yes. And in your arguments just now, you mentioned that you're targeting, right, certain individuals. And targeting with those ads and targeting with those with the additional information.
Well, not exactly targeting certain individuals with ads. What we're doing is, taking user information and other information. I want to be clear about when you look at the state's complaint, look at paragraph 9 and paragraph 67, 66 and 67. They are not arguing, they're not alleging that we are only spitting back to a user what the user wants to see. They're arguing the opposite. In those paragraphs, the state says, we don't like the message that your compilation sends because, among other things, you actually give people things they don't want. And that's what creates a problem. So the state is objecting to the message, which is exactly what the First Amendment exists to prevent the state from doing. It doesn't get to decide that some speech is different from others. And back to your question about there's design elements, those elements are used to create the third-party compilation. And just last week in Childs versus Salazar, the Supreme Court said her speech does not become conduct just because the state may call it that, calling the elements, design elements here, speech. The First Amendment is no word game, and the rights it protects cannot be renamed away or the protections nullified by mere labels. So saying that the algorithm and the way that a publisher selects.
But I would go back to my point. Who, and I guess in this regard, I can't believe I'm asking this, who or what does the First Amendment protect?
Yeah, I mean,
because it's not a human being. It's not it's not Ben Bradley making this editorial judgment. It is a faceless, bloodless algorithm.
Exactly. It's AI. So was the First Amendment designed and written to protect AI?
So it's not, just to be clear, I don't want, it's not AI. It's the corporation that is making decisions. Here's what the Angelilli
based on an algorithm, which is
algorithm and a variety of factors. But here's what Angelilli says. I think this is unassailable. It applies to algorithm-selected videos when the algorithm is, quote, developed by humans.
Is that what the First Amendment says?
It's describing
in the First Amendment of the Constitution.
No, it's saying it applies to algorithm-selected videos.
The case? What do you?
No, the First Amendment applies to when they're selected.
When I read the First Amendment, I don't recall anything in the first, and it's been a while since I read it, that talked about algorithms.
No, but
so what are you referring when you said it? What are you?
I mean, the First Amendment says Congress shall make no law abridging the freedom of speech. Right? This is speech.
Including algorithms.
It's not algorithm. The speech it's the compilation that is produced by choices made by humans to design and implement the algorithm. Right? Humans implement, they monitor, they adjust, they use the algorithm, and it's humans who decide on the output, what's going to be published. When it comes out, a human and the corporation that's run by humans says, this is what we want to produce. We've used an algorithm and other tools to make this compilation, but this is the compilation we stand behind as a company, and it's expressive in many ways, not least because the feed for TikTok looks different from the feed for Facebook, which looks different from the feed for Snap. They all make different judgments. They've designed their algorithms differently to produce different compilations expressing a message.
They're just different products, that's all, with different faces on them that pushes information to people.
They're different compilations. You're saying product, but that doesn't answer the question of whether or not when the product, even if you use that label, is a speech product. I mean, the New York Times is a product, right?
You say
it's
that
a product of speech.
You say that the user asks for this information.
Interesting information.
But all the user does is open up
TikTok.
But what I'm saying,
and here it comes. And if you take a look at it long enough, here comes the next one. So how is the user asking?
I mean, it's implied because that's what the TikTok service is. It's an entertainment platform that somebody opens and says, I would like to be entertained now, or I'd like to be informed. There's all kinds of educational information on it. And so they open it up and say, what is going to be entertaining today? And TikTok and Snap and Facebook each compete, right, with each other to provide a more entertaining platform, more entertaining stream, an interesting stream of videos, and they make different choices that result in
users between Facebook and TikTok. I think that the young folks that we're talking about, they're not on Facebook.
Right? With respect to,
but I'm just saying it's a different population, and it's presented in a different way.
Well, so first of all, it's not in the record, and with respect, it's not factually correct that there are lots of overlapping users between Snap, TikTok, Facebook. And the point is, even to the extent they're different, TikTok definitely isn't like just kids, right? All kinds of like millions and millions and millions of adults use it. And the point is, even to the extent there were different audiences, that would only underscore the point that each of these platforms is making different expressive judgments in the way they program the algorithm to produce what's referred to as a third-party speech compilation, which is a speech
still,
product.
the bottom line is, their question is whether or not the way in which it's produced and the way in which it's pushed out is addictive and therefore is causing issues to children.
Is TikTok permitted to, oh, I'm sorry, you had a
Well,
response.
just to
Go
be
ahead.
point, the addiction is just the harm, right? And there's always the harm in cases like this, just as there was in Brown, right? The violent video games were said to be harmful, and that didn't answer the question if that means it's not speech or that means it's not protected. That was just the state's justification. The court said it's speech, and because you're concerned about harm, is what triggers the First Amendment's application, because the
Yeah, but
First
not all
Amendment.
speech is protected, right?
I mean, well, speech is, to the extent it's expressive speech, it's protected.
Not all speech is protected.
Well,
Our
there's different
social,
layers.
that was going to go to my
Commercial-
question.
Yeah,
Are
yeah,
social
there's
media-
commercial speech, right.
Are social media companies permitted to direct to minors sexually explicit material?
And they would be subject to the same rules that would apply to.
So there are cabins to speech, particularly with immature audiences.
Yeah, but the question here is whether a third party, what the state is saying is the mere fact that you compile speech and use algorithms and other tools to do so means it's not speech at all. So if the state is right, you could prohibit it as to adults. Their argument that it's not speech isn't about children.
Well, I guess that
and
would
it's
go to
not
their,
expressive,
also
right?
to their parens patriae powers, though, might be stronger with respect to children, but
I mean, the problem they have-
weaker with respect to the broader
Right,
audience.
the problem they have there is parents are perfectly equipped in this circumstance to represent the children, and there's no difference here. But their argument is not.
Well, we will hear from the state now. Yeah.
Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the Court. Grace Sow for the Attorney General. This Court should affirm the denial of defendant's motion to dismiss. I'd like to just briefly address the state's parents' patriae standing before delving into the merits. Defendants do not contest that this case implicates the state's core quasi-sovereign interest in safeguarding the health and well-being of minors, and there is no dispute that the alleged harms here impact millions of children and teens in New York who currently use TikTok or who will soon be exposed to the platform when they come of age online.
So, counsel, what is the allegation of the actual product here in the complaint?
Sure, so the complaint alleges that TikTok itself is a product. I strongly disagree with my colleague that products have to be tangible or have to have a tangible analog. Instead, the relevant test is whether the distribution and use of the alleged product approximates any sort of tangible or physical product. And I think the complaint clearly alleges here that defendants develop, design, distribute, market, and profit from TikTok just as they would any physical product.
Well, what they're saying is that it's a compilation. They're compiling speech and presenting this compilation. I guess it would be like an album or something that they're pulling together different, like how back in the day you would make a cassette with different music genres on it.
Cassette. What is that?
I mean, to the extent the court wants to find different physical analogs as to the different features that we're challenging here, we think that the For You feed looks a lot like a slot machine, and it's designed and addictive in exactly the same way, just as a gambler wants to pull a slot machine lever over and over again to chase a jackpot.
But how do we get past that being like speech from different people just pulled together in a way that they say is interesting versus it being an actual product?
So I think that this is a product in the same way like a child's toy would be, a child's entertainment or a child's toy would be a product. It serves the same function. Kids use it the same way to engage themselves. And critically, under New York law, the important test for whether in design and warning cases something is a product is whether defendants have control over the design of the product, whether the design is standardized across the product, and whether they have superior ability to know about and therefore warn about dangers.
This
But
goes back-
the different videos are not created by TikTok. They're created by a person who then uploads them to TikTok. How do we get around that and make that an actual product that TikTok is creating.
Because they're the intermediary. They're simply the ones that are putting it out there. They're not creating the video.
That's true with respect to the video content, but I think that TikTok is still, the platform is still very analogizable to any sort of toy, for example, that might just show certain images, or to a slot machine that just shows certain cherries or whatever images are flashing on the screen of a slot machine. It still functions in a product in the same way. And I direct the court to decisions that we've cited in footnote 15 of our brief, where courts around the country have found social media platforms to be products, or at least assumed as obvious that they can constitute products. And to the extent that the court wants to break down each of the component defects that we've alleged in our complaint and seek physical analogies to them, we have explained in our brief that they are analogous. So I just talked about the feed. For notifications, for example, we allege that those are harmful to young users' sleep. That's very analogizable to a pager. The federal MDL found that faulty parental controls and time restrictions are very analogizable to a broken child lock. So I think that to the extent the court cares about tangibility, and we would strongly push back that tangibility is paramount, there are physical analogs here that the court can look to guide its analysis.
What about the First Amendment in terms of speech?
Sure. So
And specifically Brown, where we talked about content, movie content, right?
So I don't think that this case, we strongly disagree that simply designing and implementing addictive features is protected by editorial discretion. The court's case law in Tornillo, Hurley, and Moody make clear that editorial discretion is intended to protect against government interference with a publisher's intended expression or message. And here, defendants have simply failed to explain how adopting addictive features whose sole purpose is to maximize young people's engagement on the platform is expressive in any sense. At most, I think I've heard my colleague try to analogize this to an anthology, but I think there is a world of difference between the two. Whereas a magazine editor, for example, exercises her independent and content-specific judgment in selecting which articles to include and exclude from a magazine article, defendants are exercising no such judgment, no such content-specific, no such independent
Well, if I
judgment.
understood your friend correctly, the human element is at the beginning, that the engineers or the computer scientists, whoever they may be, who sit down and design these algorithms, they are, I guess they're essentially in some ways delegating or ceding the judgment by virtue of the algorithms, but there is they're adopting the editorial judgments as it is from the algorithm.
So I think the Moody case makes clear that where a defendant platform is doing content curation through an algorithm that uses independent content standards that the defendants themselves have chosen, that sort of use of an algorithm can be expressive. But that's not what we have here. The complaint clearly alleges, for example, in paragraphs 206 and 208, that the algorithms that we are challenging, the addiction-based ones, are based on user inputs. That means it's not based on content standards that defendants think are good or entertaining. It's instead based purely on the user's own past behavior on the platform, and Moody expressly carved that kind of algorithm out of its decision. So we think that the algorithm here looks very different from the one that's at issue at Moody, and Moody really does not govern this case.
This is a 3211 motion, right? This is a 3211 motion?
Yes, it's a
So
motion.
none of this really has been fleshed out. We're just looking at your allegations in the complaint.
That's exactly right, Your Honor, and we think that we've done enough to plead that the algorithm here is different from the one in Moody, and to the extent that my colleague wants to dispute that, that's a factual issue. It's not a proper basis upon which to dismiss our claims here.
To what extent is your action predicated on information provided by third parties to TikTok?
It's our position that it's not at all. We are challenging TikTok's addictive design features, and we are not at all challenging the publication of harmful third-party content. That is what sets our case aside from cases like Force and Dry Off and MP that my colleague cites in his brief, and that is why 230 does not apply in our case to bar our claims. So here again, features like endless scroll, features like autoplay, they are content agnostic, and we've clearly alleged in our complaint that they are harmful to minors because they suck them into the platform and keep them there regardless of the substance of videos that they're watching. So our addiction-based claims here look very different and are not predicated on the substance of any content that's provided by a third party.
And are your claims in this case, the injunctive relief you're seeking, limited to children? Maybe you've specified what that, minors, legal minors?
Yes, we are seeking an injunction to have defendants remedy their addictive designs with respect to minors in New York. That is the scope of injunction that we're seeking in this case.
And is your friend right that that would be a slippery slope? If we were to recognize this sort of lawsuit here, the next step would be to intrude on the government's intrusion on speech directed towards adults?
I don't think so, Your Honor. I think that the court can draw a very clear line here, and our claims certainly do so. We are seeking to proceed parents patriae on behalf of children and teens in New York, so I don't think that this case at all bears on adults, and I think there could be a separate, for example, First Amendment analysis that a future court could apply to adults if a claim were to be brought, but this case does not present that issue here.
Thank you.
Thank you.
Thank you, Your Honor. Just a few points working backwards. It's just not accurate to say that if the court were to determine that this is not speech and not expressive, that wouldn't apply to adults. That might be a different analysis about the level of scrutiny or something, but there's not a serious argument that it could possibly survive strict scrutiny. The speech is either speech or it's not speech. A third-party compilation is either a speech compilation or not a speech compilation. It doesn't matter why the state is trying to control it.
Well, I guess critically then, your friend argued, and I think it's in her brief, that I think to use her words, content agnostic, that we are focused on the addiction fueling algorithm, regardless of the nature of content, and that's our challenge, and therefore isn't subject to sort of a First Amendment scrutiny.
I think that argument in the brief is about Section 230 when they're saying it's the puppies versus porn thing. They not worried about specific content. I don't think there's a credible argument that they're not focused on the content of the speech compilations, because what they're saying is the speech compilations produced by an algorithm and other tools are addictive. That's the overall compilation is problematic, and we need to change the compilation and do a different compilation that won't be addictive, looked at in the aggregate. And she just said a different one for kids than for adults, right? Because the compilation harms kids, and there would be a different analysis. So the First Amendment argument definitely applies directly to the compilation, and they are definitely arguing that the compilation itself, the overall aggregate content of the compilation, is what's problematic. Just looking at the allegations.
You don't believe that the government would have the ability or a company should have the ability to monitor and therefore filter speech directed at children or minors as opposed to adults?
Companies absolutely, and of course TikTok does.
So you don't believe that the government has the authority to state to TikTok that you have to monitor or somehow put the clamp, make sure that certain speech, a certain content is not given to children?
That's correct. The First Amendment says make no law, and it doesn't, we know from Brown, it doesn't apply differently. The argument that speech may be harmful to children is not a sufficient reason to say, certainly not a sufficient reason to say it's not speech. I mean, and the whole point of the First Amendment is to say.
How would we protect the children if in fact this is addictive? How do we protect them?
I mean, there's all kinds of other ways that you can go about assisting parents and having, in their ability to get their kids to, control phone usage overall, right? That's a significant one. The blunt instrument of tort law, that's the problem with calling this a product and using product liability and seeking punitive damages, the whole idea without making any calibration, for example, as a statute might try, and we're not saying a statute would be constitutional, but a statute that might try to say, like, for example, they don't draw a distinction at all in their tort claims between kids whose parents allowed them to use it, wanted them to use TikTok because of the various educational, informative, and entertainment benefits. There's no distinction there. They just would have punitive damages based on everybody, and that is absolutely intolerable under the First Amendment. And that can be evaluated at the pleading stage, as it was in Patterson, as it was in Angelilli, as it is frequently in the First Amendment context. We take as true their allegation that they're trying to regulate a third-party speech compilation, and that's the First Amendment problem on its face, even if you accept that the third-party speech compilation is one the state doesn't like because it asserts that it's addictive. Again, that's true in all speech regulation cases. The state has a theory, the state has a reason for doing it, but that's never enough to say that the First Amendment doesn't apply, and it's certainly not enough to say that it isn't speech.
Any questions? No? Thank you very much.
Thank you, Your Honors.
Molachek v. Exxon. Yes.
Good afternoon, Your Honors. May it please the court. Andrew Ditchfield, along with my co-counsel Mark Zouderer, on behalf of the appellants. The core question in this appeal that this appeal presents is whether the court below endorsed an interpretation of this contract that says that these plaintiffs were granted more rights and are subject to fewer restrictions now that the contract is terminated than when it was when the contract was enacted. This dispute has a history. It's already been before this court, and it's been up to the Court of Appeals. And in the first iteration, the focus of this case was on whether a no-action clause in the contract barred the plaintiff's claims. The plaintiffs argued in that iteration of the litigation that the no-action clause did not apply, did not preclude their claims. And the Court of Appeals, this court, the lower court, all disagreed. The Court of Appeals ruled that the no-action clause did preclude, required dismissal, and it held that the plaintiffs lacked standing because they were not required holders. Required holders, capital R, capital H, is a defined term. It's specifically defined in the agreement. It requires ownership of at least 25% of the EVR interest here, and that ownership has to be reflected on something called the EVR register, which is created by the contract. The right to assert claims under the no-action clause is only conferred on required holders. The plaintiffs don't meet that contractual definition. They're barred from bringing suit. The Court of Appeals also explained that under this agreement, the holders only have those rights that are expressly set forth in the contract. That ruling was drawn from the plain terms of Section 805 of the agreement, which is at R 699, and that provision says that holders, quote, will have no rights hereunder except as are expressly set forth herein.
So you agree, I guess, that the CRPA terminated shortly after the CR payment was made in 2017?
September of 2017, so shortly there.
And the CRPA had a survival clause, as you mentioned, right?
That's correct.
Okay, so was 304 in that survival clause?
So there's two parts of the survival clause, Your Honor. There is a portion of the survival clause that lists several provisions. 3.04 is not one of them. There is a sentence at the end of the survival clause that says that the termination of the agreement will not affect or limit the interests of the holder. It goes on to say, to the extent accrued distributable to the holder prior to the termination of this agreement, and the provisions applicable thereto will survive the expiration or termination of this agreement. Now, I'll grant you, Your Honor, that 304 is not one of the specifically enumerated provisions in 8.11. If you look at those provisions, I just want to tick through them quickly.
That's how you get on the EVR register, right? What you're saying is a predicate.
How you get on the EVR register is through 3.04, yes.
3.04,
yes.
right.
But the provisions that are specifically called out and enumerated in 8.11 are 3.05, which has to do with the tax treatment of the payments under the agreement, 4.01, 2, and then several provisions of 4.02, which relate to payments and indemnification of the escrow agent, and then sections 5.02B and C, which relate to the liability and indemnification of the holder committee, and then Article 8, which is the miscellaneous provisions, including the no action clause and the termination provision. Those provisions themselves relate to very specific pieces of this contract.
Who keeps the EVR register anyway? How is that maintained?
So by the contract, this is a contract between, I'll just call them ExxonMobil and ComputerShare. ComputerShare is the escrow agent. They maintain, they're charged with maintaining the EVR register. I see that my time is up. Just want to make the final point, which is, if it's the case that every other provision of the agreement falls away, then the latter part of the survival provision has no meaning. The latter part of the survival provision is all about the provisions that apply to distributable CRP payment. That is exactly what this case is about. The plaintiff's claim is that ExxonMobil did not pay enough distributable CRP payment. If they're right, then they will get more CRP distributable payment. That all of the rights and obligations and provisions that govern that have to be applicable to that distribution process. Otherwise, there's no way to distribute the proceeds. So, thank you, Your Honor.
Thank you, Your Honor. Jenny Kim for respondents.
Given your friend's last point, do you agree with that, what he just stated?
No, Your Honor, we don't agree with that at all. We are not seeking another CR payment. Actually, under the agreement, sections 3.05 and sections 8.11, there is only one CR payment that is made under that agreement, and as soon as that payment is made and a couple of other steps are triggered, the contingent resource payment agreement terminates. We're not seeking another payment. What we're seeking is relief for Exxon's breach of its good faith obligations, which are listed in section 6.02, and we're seeking compensatory damages for that breach. In fact, this court has held in Automobile Coverage versus American International Group, 42 AD 3D 405, that when a contract terminates, just because you sue for breach, that doesn't mean that all of a sudden provisions in the contract that have previously terminated are revived again. I mean, if that was true, termination clauses and survival clauses would have no meaning.
If we were to accept your reading of the CRPA, what meaning and effect would that last sentence of 8:11 have?
There are other sections in the agreement, Your Honor. For example, section 6.03. Section 6.03 is a guarantee by Exxon, the parent, of all of the obligations of Acquisition Co., which was a subsidiary of Exxon, including all payment obligations. So section 6.03 would obviously survive termination of the agreement. Section 6.02, which is what we're seeking breach of, right? We're seeking relief for Exxon's breach of section 6.02, which lists all of Exxon's obligations which vested prior to the termination of the agreement. Those would survive as well. That last sentence in section 8.11 really stands for the unremarkable principle that if your contract rights vest prior to termination of a contract, you don't lose those rights because the contract terminated unless the contract expressly states. And that's actually a very
You're reading the portion that says payment shortfall to the extent accrued distributable to the holder prior to the termination of this agreement and the provisions applicable thereto will survive the expiration or termination of this agreement?
Yes.
Maybe if you had drafted that sentence, we wouldn't be here.
Maybe, Your Honor. But we do think that that last sentence, I mean, there is plenty of New York case law out there that establishes that once contract rights vest prior to termination of an agreement, that those rights do not terminate just because the contract terminated. In fact, right, that's why you can actually sue for breach of a terminated contract. And that sentence is really just saying, if you have rights prior to termination of a contract, that those payment rights are not going to dissipate. Also, there's a number of other provisions that list out the fact that, there's a 9-month period after the contract terminates, where if certain holders did not receive their payments, they would be still entitled to those payments. Those sections would also survive. I think what I would like to focus on for the remainder of my time is Exxon's basic argument. Exxon's basic argument is that Sections 3.03 and Section 3.04, which are the non-assignability clauses, these are the clauses that preclude assignment unless by operation of law, like death, for example, that those survive even though they're not listed in the survival clause of 811. And that is contrary to established law in New York that guarantees the free assignability of contract rights, and that also requires that any restrictions of assignability have to be expressed. It is also counter to decisions from this court that says that you can't interpret a contractual provision like the last sentence of Section 811 to say that certain rights granted under the contract or restrictions or obligations will last in perpetuity. But if you take Exxon's interpretation and says Section 8.11 means that these interests are not assignable forever, that's exactly what Exxon is asking this court to do.
3.03 isn't sufficient?
Isn't sufficient for?
Deal with the general rule about we don't want to retard the alienability of contractual rights?
Because Section 3.03 wasn't expressly in Section 8.11, so it doesn't survive termination of the contract. Sections 3.03 and 3.04, and Justice Barak understood this because he handles all the Securities Act cases down in the commercial division. Those provisions were inputted into this agreement because Exxon did not want these escrow verification receipts to be registered under the Securities Act. And we went through this analysis step by step in our briefing, but also before Justice Barak and at oral argument, and saying that you have all these non-transferability and non-assignability clauses here because non-transferability is one of the critical characteristics that the SEC looks at to see if a security should be registered. Obviously, once the CR payment is made and the contingent resource payment terminates, those concerns no longer exist.
Thank you.
Counsel is correct that the non-transferability restrictions are in significant part motivated by the desire not to have these be registered securities. What they've never answered is why that stops when the contract terminates. If these EVRs still exist, and if they can still get paid out on them, then there still presents that risk. Your Honor referenced 3.03 using the phrase "at any time." They are not transferable at any time. That was done for a reason. The argument that under 8.11, what they're really seeking here is damages. Their entire theory is that there was a shortfall in the payment of the CRP that was made. We're not contesting that they can't pursue those rights because 6.02 isn't listed in the termination provision. We're recognizing that those rights vested before the contract terminated, but that's the point. And you have to look at what provisions apply to that payment in order to understand what rights and obligations exist. And they've never answered the question. They concede that they are not required holders. You have to be a required holder to bring claims under the no action clause. This court agreed with that argument, and the Court of Appeals agreed with that argument. The Court of Appeals also said, and there are no other rights for these holders except those expressly set forth herein. Their argument is they get many more rights and none of the restrictions if once the contract has been terminated. And that is absolutely contrary to what the contract says, and that's absolutely contrary to the Court of Appeals' first decision that found that there was no standing.
But in the Court of Appeals, they didn't have to address the registration requirement, and they did not, did they?
They didn't have to, Your Honor, but the import of the Court of Appeals' decision is you have to be a required holder, and you don't have any rights except for those expressly set forth therein. Those are the two central elements of the Court of Appeals decision. So the question that I ask is, are they required holders? And you don't have to take my argument that the answer is no. They concede that the answer is no. And thank you, Your Honor.
Thank you both. Garcia v. 267 Development, LLC.
Good afternoon. May it please the court. Chirag Titsangi from Galvatucci Clark for the second third-party defendant appellant, Chutes and Compactors of New York. Your Honor, Chutes' role in this matter is contractually defined to installing a chute and compactor system at the premises, and that's exactly what they did. The compactor was installed and was complete with the safety gate, which is now the center of this dispute. Mr. Cagg, Chutes' general manager, actually testified that every compactor leaves with the safety gate installed and that the installation invoice was marked complete, meaning that it was tested and it was functioning. Chutes' contractual obligation ended there.
What do we know about the March visit, though, counsel?
The March visit?
You know, the March visit, I mean, say the safety device was not on top of the chute at that time, shouldn't the maintenance worker have jumped up and down and said, listen, you really need to get one of these, and, you know, call an emergency? We don't know what happened in the March visit, right? Essentially, your argument is we don't know if it was there or if it was not there. But say there's some evidence that it was there, did the worker have some obligation at that time?
Absolutely, Your Honor. Well, the March visit concluded that Charlie, who was the repairman who was sent there, was there for a motor issue, and that's why the compactor wasn't working. So his scope was limited to just working on that motor and not holistically on the safety part of it.
Is the motor adjacent to the rest of the compactor, though? Do we know from the record?
It is, yes, Your Honor.
Okay. So, you know, I'm just thinking, I mean, what if the compactor was on fire or something? I mean, didn't he have some obligation to say something about some problem with the compactor, if there was one?
Absolutely. You know, I think we obviously don't have Charlie to depose, but what I will say is in Mr. Cagg's testimony, he was talking about the policies and procedures in place. His report would have said if it was missing or if it was not there. So the lack of it not being the report.
That's the inference you wish us to draw, is that obviously it must have been there because he would have said something.
Absolutely.
And that was months before the plaintiff's accident.
Yes, Your Honor. It was about 5 months, I believe, 4 or 5 months before.
And you had left 1 year prior to that, right?
Yes, the installation was, I apologize, go ahead. Oh, the installation was actually done in March of 2012. Charlie came to do repair in March of 2014, and then 5 months after that was when the injury occurred.
Thank you.
Thank you, Your Honor.
Good afternoon. May it please the court, Edward Nicholson for the respondent 267 development, and I'm going to ask that the court uphold the denial of the third-party defendant's motion for dismissal. The court correctly found that facts were in dispute as it related to when the safety guard was removed or was missing.
So when, go ahead.
It's not disputed that when the chute was installed, it had a safety guard.
Yes, that is not in dispute at this point.
Okay, and then chute was had a 1 year contract after installing?
They had a 1 year warranty.
Warranty. So they would have been, if something went wrong, then they would have been called in.
Yes,
to correct whatever
yes.
defect was in the chute.
Yes, if it happened within that year or something needed to be replaced, I would assume, yes, that would be covered under the warranty. But in this case, and as Your Honors correctly pointed out, it's really the question of fact is what occurred at that March 14th, 2020.
But by
2014.
by 2014, how long had that chute been in?
I believe it was close to maybe 3 or 4 years.
3 or 4 years. So that 1 year warranty had already expired.
Yes.
And was there a service contract between chute and the building owner?
There was no particular service contract in between Chutes and the property owner or even the property management service, who's also a defendant.
So it was someone from the property owner or whoever did the maintenance for the property owner that was dealing with the chute for those years up until the point that they went in, the chute went in for the service call.
Yes. Yes, it wasn't a chute operator using the actual compactor. The question is whether or not the chute employee here, Charlie, who has not been deposed in this action, who we do not know what his testimony would be, is whether or not he acted reasonably at the time of the March 14, 2014 repair log. Or
would they have a duty to inform the owner that the cover was missing? At that, if they if they found out that there was no cover at that March 14 visit?
Yes, and I would point the court to the Eves Brooks costume case, where the court noted that the proper inquiry is simply whether the defendant has assumed a duty to exercise reasonable care to prevent foreseeable harm to the plaintiff, and also the Warblaski versus Otis Elevator case, where the court found that having undertaken to inspect, the defendant was obligated to perform such inspection in a reasonably careful and prudent manner. And it's our position that whether or not Charlie performed that inspection or that repair or that call in a reasonably prudent manner is a question of fact for the jury.
Wouldn't that only be the case if we had some inkling whether or not the covering was on or not? In other words, we have no evidence that the covering was not present when he was there in March.
At this point, yes, Your Honor, but
so you need to
material
issue a
facts
tribal
will come
fact to
out.
survive summary judgment. So I think that's an important, I don't know, to me, explain to me why I'm wrong quickly, why that's not an important fact to know that the cover was missing on the March visit.
Well, it's not that it's not an important fact. It's just that it's a fact that has to be determined by the trier of fact as opposed to the courts in this instance, and that it's something that should go to a jury. And we feel that dismissal at this point would be premature, and that there has been no findings of liability or causation at this point, and believe that the lower court's ruling should be upheld.
Thank you.
Thank you.
Your Honor, this court's decision in Rosa and Nyambu established a clear and bright line rule that absent a systematic maintenance contract, an independent contractor has no duty to inspect, warn, or install any safety devices. And as alluded earlier, there was no systematic contract here between 267 and Shoot. In regards to respondents' position on Robowski, I would say that there is a big difference in the facts of that case and here. In Robolowski, the difference is that the elevator maintenance mechanic was called specifically because the operator complained about the elevator's performance, and he responded to that specific complaint. So his duty arose from the direct nexus between the complaint and the inspection and the malfunction that caused the injury.
So it was your motion for summary judgment, is that correct?
Yes, Your Honor.
And did you put in an affidavit or anything from the individual who performed the work in March that the cover was there when he performed the maintenance?
I don't believe they did that in the lower court, Your Honor.
Thank you. Thank you both.
Thank you for your time, Your Honor.
Variano v. Variano. Yes, whenever you're ready.
Good afternoon, Your Honor. Of course, we've appealed the summary judgment decisions. There were two of them. The first and main point was that STD claim. It, first of all, was not even pleaded, and secondly, was not even proven, and at a minimum, the prima facie case was not met, but more importantly, there were such defects that judgment should have been granted to the movant, Anthony Variano, on that cross motion. First of all, it was a completely new theory of liability, which are prohibited. The complaint within the battery claim did not mention a word or acronym about STD, HPV, sexual transmitted disease. What did the battery claim state? Punching, kicking, grabbing, and biting. Nothing about sex. So it was not even in the complaint. Even as a notice jurisdiction, a claim should be stated. We have procedural rules. A claim should be stated. The elements of the cause of action should be stated, and facts related to those elements should be stated. As a result of that not being pleaded, defendant was surprised and prejudiced. In terms of damages, we went from a possible cut lip case to a possible cancer case. So damages were amplified tremendously. Furthermore, it precluded full medical discovery, paper discovery, depositions, and expert discovery on that whole subject matter. In terms of the STD not being proven, causation was not proven. There was no competent, admissible, expert proof on that subject matter. Medicine, diseases, that kind of thing, they are expert areas. They're not lay areas. The typical narrative report has a history, chief complaints, findings of the physical examination, a diagnosis, and an opinion on causation. None of that was here. We had standalone diagnostic test reports. Other causation factors were not ruled out, like contact with the surface. Main point, the Court of Appeals gold standard, submitting a contemporaneous medical record, was not met. What movement submitted was something from a year and a half later. There was no proof the defendant had this HPV condition. There was no proof the defendant knew he had it. And importantly, the whole either comparative negligence or consent issue was not even addressed. Here's a woman who in October of 2015 saw symptoms on the genitalia of the defendant, treated it with a cream, and then 2 months later goes on to marry him. And in the interim, goes on to have sex with him. That is de facto consent, which would defeat an intentional tort. So to summarize on that part of it, there was no proof of defendant's diagnosis, equivocal proof for the plaintiff going from negative to a positive test to another negative test, which is equivocal and cancels out the standards for summary judgment. There was no narrative medical report exchanged or submitted, which violates the uniform rules of the trial courts. And then finally, the consent was not mentioned or explained away. Another major basis for granting judgment to the defendant, or at a minimum, just sending it to the jury for fact determinations on credibility, is credibility. Defendant
You can address
raised.
that on rebuttal, counsel. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Maria Prietti, I am the plaintiff respondent. This appeal is very straightforward. The Supreme Court properly granted summary judgment because I established a prima facie case through admissible evidence, including sworn testimony, documentary evidence, witness affidavits, certified medical records, and police documentation. After I met my burden, the burden then shifted. Appellant did not meet that burden. He submitted nothing, no affidavit, no witness testimony, no expert, and no documentary evidence. Instead, appellant relied solely on an attorney affirmation with nothing but rhetoric, offering gross mischaracterizations of the record and arguments unsupported by admissible evidence, which are insufficient as a matter of law to defeat summary judgment. There were no inconsistencies supported by admissible evidence in the record, and contemporaneous admissible certified proof established that my HPV diagnosis mere weeks after last sexual contact with the appellant. Because the appellant failed to submit any admissible evidence whatsoever, creating a triable issue of fact, the Supreme Court's decision should be affirmed. Regarding the HPV causation, was established by the timing of the diagnosis and my sworn testimony that the appellant was my only sexual partner during the relevant period. I proved that I was HPV negative directly before marriage, and I tested positive shortly thereafter, mere weeks after my last sexual contact with the appellant. This supports a reasonable and unrebutted inference of transmission. As for the diagnosis of the defendant, New York law does not require a plaintiff alleging wrongful transmission of a sexually transmitted disease to produce a medical diagnosis of the defendant. In fact, defendant was precluded because he refused to turn over his medical records. There is no case law. Appellant cites no controlling case authority requiring expert testimony in every HPV transmission case. Intent. The Supreme Court correctly found that respondent made a prima facie showing that I acted without fault, and appellant failed to rebut that evidence.
Thank you.
The other material defense raised by defendant was credibility. He raised it both in his brief in opposition as well as in his reply to the statement of material facts and also to the moving party's affirmation and support. On the major credibility contest is this prior inconsistent statement. On the main material fact pattern, plaintiff had told the NYPD that it was a verbal argument with no injuries. That is in the record, by the way. It is in discovery responses. It was referenced in 2 items that were docketed to the electronic docket. It was served in discovery. That NYPD report is bait stamped, and plaintiff has had it for years. In fact, she gave the content and information to the police officer shortly after that incident. It is a prior inconsistent statement. And as we know under the judiciary law, a lawyer has a duty to tell the truth under the rules of professional conduct. A lawyer must have candor to the tribunal.
Thank you, counsel. Thank you both.
Thank you very much, Your Honors.
Last case for argument is People v. Jose Cabrera. Yes.
Good afternoon. May it please the court, Legal Aid Society by Everett Hopkins for Mr. Cabrera. Your Honors, this court should reduce Mr. Cabrera's sentence in this case in light of his severe drug addiction so that he can get the chance to attend a residential drug treatment program while incarcerated. Just to be clear, no matter what this court decides today, Mr. Cabrera is serving his sentence of 10 years in connection with his federal case. So he's scheduled to get out around 2030. So no matter what, that's not going to change. But the only thing we're here for is that this court can help him get the residential drug treatment program that was recommended by the federal judge in that case by reducing his sentence in this case.
How would that assist him in getting the treatment?
Well, because the Bureau of Prisons has a point system that they use to determine where to place inmates. So that depends on the type of crime, criminal history, the age of a defendant, or other detainers. In this case, Mr. Cabrera has a detainer from New York for his 9-year sentence. So that's going to
let the feds. So that's with the feds, right?
No, that's the New York case that we're here before now.
No, but isn't this the one where it was running with the feds, or is this another?
He's in federal custody now. He has 2 cases going on, right?
He's in federal custody. So
Right.
you're saying that reducing his sentence, his state sentence, 1 year would allow the feds to place him in a residential drug treatment program?
Right. So reducing it by 2 years to the minimum 7 years. He's doing a 10-year sentence now in federal custody on a federal case.
On this case, he was sentenced that the state sentence was set to run concurrent with the federal sentence, right?
Correct. But what it is now the federal judge made a recommendation that he be placed. 2 things happen. He be placed in a specific prison in FCI Raybrook, which is upstate New York, and that facility then put him in a residential drug treatment program. He's currently in Kentucky at USP McCreary because of his point totals. His point totals were above 30 points, and so because of that, they put him in a maximum security prison. Now, if you reduce the sentence on this case, the points he got for the detainer in this case, which were 7, he could petition to have those points removed once his sentence expires on the state case. So by reducing his sentence, that allows him to he can quicker apply to have those 7 points removed from the Bureau of Prisons so that he can then apply and say, listen, I want a reassessment of my points because I'm no longer serving the sentence in this case.
After he does his 10 years?
It will be during his 10-year sentence. But by shortening this sentence in this New York case to 7 years, he now has the ability to start his residential drug treatment program if Bureau of Prisons, of course, is not guaranteed, allows him to transfer.
Like Willard. I'm sorry, go ahead. Yes, I apologize. Go ahead.
That would allow him to transfer, like Willard, I know, but would allow him to transfer to FCI Raybook, which has the program that was recommended for him, and that's what he needs to really get his treatment.
Sir, do you want to address the appeal waiver?
Sure, I'll address that briefly. We think it's defective for 3 reasons. First, of course, the timing. It's our position that entering a waiver after pleading guilty could affect its voluntariness and
We've already stated that.
correct. The second department hasn't, so that's why
Now
we
they've
always
come
bring it up.
around to our way of thinking.
But most importantly, Your Honors, the colloquy was ambiguous here. First of all, it mischaracterized the waiver as absolute, barred to appellate review, which of course is not true. The court hinted that the plea would normally be final by all effects of this waiver. Additionally, the court doesn't explain the right to counsel survives the appellate waiver. Now, the court does, to its credit, discuss that he has the right to appellate counsel and that one will be afforded to him if he couldn't afford one. However, when it discusses the effect of the waiver, it doesn't mention anything about that right. So it leaves one to wonder whether that right was just waived or whether that's still in effect. Additionally, there was limited inquiry into the understanding of the written waiver. It seems that the court just asks if the written waiver was signed while his attorney was standing next to him. It doesn't do any type of adequacy or adequate colloquy into whether he actually read and understood the written waiver
Thank you.
for
You have
himself.
time on rebuttal.
Thank you, Judge.
Good afternoon, Emily Aldridge for the people. The waiver colloquy essentially mirrored the model colloquy, which is endorsed by this court and the Court of Appeals, therefore precluding all of the excessive sentence claims. Regardless, his sentence certainly was not unduly harsh or severe. Anything related to what's happening with the feds is simply outside of this record. To the extent this court chooses to take judicial notice of what's available in his facility in Tennessee, it does offer a residential drug treatment program. But again, regardless, he was indicted for attempted murder. He availed himself to a plea to criminal possession of a weapon. It was concurrent to completely unrelated federal conviction. There's no reason to feel this was unduly harsh or severe.
Thank you.
Just one quick note, Your Honors. Bureau of Prisons does say that all of their facilities have some level of drug treatment. However, of course, simply because there's access doesn't mean that he's eligible for it or that it's sufficient to meet his needs. Of course, a residential program is much more comprehensive than a one-day class, a one class a week type of situation, which I think is what Bureau of Prisons says that they have. So that's why we're asking that this court consider reducing his sentence so that he can really get the treatment he needs, so that when he's released, he has a higher landing to start off being a law-abiding citizen.
Thank you. Thank you both.
Thank you.